welcome everybody. My name is Michele Riccardi and I'm the Deputy Director of Transcrime, the Joint Research Center on Innovation and Crime of Università Cattolica in Milan. Today we are here for a training webinar within Project KLEPTOTRACE. The training is about legal basis and instruments for sanctioning and asset recovery of transnational high-level corruption. It will be quite a dense day. The agenda is very dense, and therefore I do not want to speak too much, and I immediately leave the floor to my colleagues. Let me only remind that the KLEPTOTRACE project, and in a minute, Giovanni Nicolazzo, who is the project manager of the project, will say a few words about it. Project KLEPTOTRACE has been co-funded by the European Union, DG Home Affairs, which we thank for supporting this initiative, which we think is crucial in both the research and policy area. And let me thank also the partners of the project, and especially those who will intervene today as speakers. So having said that, I immediately pass the floor to Giovanni. Please, Giovanni, the floor is yours.
Thank you, Michele. Good morning, everyone, and thank you for coming today as we start this new chapter with the KLEPTOTRACE training. In these coming 2 years, there will be other sessions that will face some of the issues that Europe faces related to corruption, asset recovery, and sanction evasion. And KLEPTOTRACE, as Michele was saying, is a EU co-funded project, a strong collaboration of 11 partners that include public authorities, financial intelligence units, anti-corruption agency, investigative journalists, and also universities, and several external supporters that include also data providers and European public authorities. Together, our mission is to improve the understanding on the latest trend in high-level corruption, to understand how sanction can address this issue, and to improve the understanding on the phenomenon of sanction circumvention and sanction evasion, which is a very topical theme, especially in relation to the large-scale invasion of Ukraine by Russian Federation. More than that, we also will try to develop powerful assets to help authorities to trace the assets of those who face sanction and assist in recovering of their illicit gains. So today's panels is exceptional. The overall objective is to deepen the understanding on the legal basis and instruments for sanctioning and asset recovery of transnational high-level corruption. We'll start with insights from Professor Matthew Happold, Professor of Public International Law at the University of Luxembourg, and Francesca Finelli, currently a PhD candidate in International Law at the University of Luxembourg, which will introduce us on the very topical theme of international sanction. And in the afternoon, after the lunch break, Celia, Challet, PhD candidate in EU sanction from the University of Ghent, and Anton, Moiseienko, a lecturer in law at the Australian University, a national university, will deepen the understanding on the consequences of sanction. So please be informed that we will record today training and we'll share it on KLEPTOTRACE website in order to amplify the reach of the knowledge that we gain today. So by participating in the training, you accept the privacy policy that you find in the link in the cover, but in a few moments you'll find the privacy policy also in the chat. And for continuous update on our progress and activities, I encourage you to follow our social media pages on LinkedIn and Twitter, and to regularly visit our website. So I don't want to steal further time to our panelists, so I leave the floor to you, Matthew and Francesca, and thank you again, everyone, for being here today.
Well, thank you very much, Giovanni. The first session is going to be done by myself and Francesca together and really provide an introduction to economic sanctions and in particular to EU restrictive measures, which is the term, as we'll see, for economic sanctions used in EU law. Then we each have a we'll each be giving a session individually. I think I'm listed as being next, and then Francesca, but we're going to swap that around. Apologies for that, but unfortunately something's come up at this end that necessitates us doing that. So I think we've got an hour for our introduction. So I'm going to speak for about half of that time, focusing on what sanctions, economic sanctions are, and how they have developed, and providing a pretty brief introduction to some of the legal issues before Francesca hones in on EU restrictive measures more specifically. So we've got a PowerPoint. Hopefully it's being shared. That's just a picture of the University of Luxembourg. So in starting, I just want to address a number of distinctions and issues of terminology. Now, the first thing I'd say is when we use the term economic sanctions, or sometimes financial sanctions, they're not terms of art, by which I mean that they don't have specific legal meanings. They're not legal definitions. In order to determine the legality of any particular measure, which is said to be an economic sanction, you have to look first of all at what that measure might be. What is it? What effects does it have? Who does it affect? And secondly, you need to look at the specific legal order in which that measure is adopted and implemented. And I say the specific legal order in particular because sanctions because they are usually specifically designed to have transnational effects, they're often adopted in one place, implemented elsewhere, and have effects even further. They're often adopted by the authorities of one state or organization against other states or persons under the jurisdiction, nationals of other states. You need to look, sanctions have effect in various legal orders, and it's fairly obvious when you look at the EU. Sanctions are adopted by the European Union, by the Council. But implementation, at least traditionally, although the Union institutions are getting increasingly involved, has been through the member state authorities. So immediately you have questions that are questions of European law, but you see implementation going on in national legal orders. And of course, sanctions can also have effect in national legal orders outside the EU restrictive measures, as they're called. Sanctions adopted by the European Union can have effect in other national legal orders. The most obvious example would be when a contract has been entered into by an EU national with a sanctioned person, or the performance of which contract would breach EU restrictive measures, but the law of that contract is not a law of an EU member state. What then is the effects of EU sanctions on the further performance of the contract? And finally, of course, because sanctions take place at the interstate level, questions arise as to their legality under international law as well. And as we'll see, it's frequently argued that EU restrictive measures are frequently argued by those states, those third countries targeted by them, breach international law. So to begin with, we have to remember, first of all, these terms are not terms of art. And secondly, when we talk about economic sanctions, and their effects, we have to look at how they apply in various legal orders. And the answers may not be the same in those different legal orders. Now, traditionally, I think it's fair to say, legal analysis on economic sanction at least concentrated on the use of sanctions by the United Nations Security Council, or sometimes called collective sanctions. If you look at the UN Charter, and if I have time, I can take you through it very briefly, you find that the United Nations Security Council has the power in certain circumstances in order to address, most notably in order to address situations where there is a threat to international peace and security, whatever that might mean, to adopt what are called non-forcible measures, which include economic sanctions. And those decisions of the Security Council are binding and must be implemented by the United Nations member states. And indeed, within the European Union, that's done by the Council, really in much the same way as the Council adopts sanctions when it adopts sanctions autonomously or unilaterally. So we have this distinction between collective sanctions, sanctions adopted and imposed by a global body, by the United Nations through the Security Council of the United Nations, and what are called autonomous or unilateral sanctions, which are sanctions adopted by states or by groups of states, by international organizations. We can see the European Union as an international organization, at least for these purposes, without, on their own initiative, without the imprimatur of the United Nations. Now, that's nothing new. States have always used such forms of pressure. They've always used their economic clout as an instrument of international relations. I was just thinking of this only today. You can go back, well, you can go back, to the beginning of the modern state system, but just to give one example, in 1906, Austria-Hungary banned the import of pigs into its territories from Serbia. It was called the Pig War between 1906 and 1908. Serbia's main export at the time was pigs. They exported them largely to Austria-Hungary. When there was an export ban, it put considerable stress on the Serbian economy, and it was designed to do so. It was a means of adopted by the Austro-Hungarian government as a means of exerting pressure on Serbia. So it's not a new thing, but there is this idea that since 1945, now we have the United Nations, maybe states shouldn't be adopting sanctions autonomously or unilaterally. Now, of course, we'll come back to this, as I said, the United Nations level, sanctions are adopted by the Security Council. The Security Council works on the basis of the veto, so that any one of the 5 permanent members of the Security Council, France, United Kingdom, United States of America, China, Russia, can block the adoption of sanctions. Of course, one thing we've seen in the last, well, it's 18 months or so, is that you can have a big crisis and the Security Council is simply unable to react because one of the 5 permanent members of the Security Council doesn't want it to act, would veto any attempt by the Security Council to act. So the argument is, if the Security, at the least, the Security Council can't act, states should be able to act autonomously or unilaterally. But nonetheless, legally, there's an important distinction because the powers of the Security Council to impose sanctions are found in the Charter. Powers of states and other international organizations to impose sanctions have to be sought in general international law, and they are far more, what the extent of those powers might be is far more contested. So we have this, again, distinction between collective sanctions and autonomous stroke unilateral sanctions. And indeed, these controversies are reflected in different uses, different terminology adopted by various actors according to their views on the legality of economic sanctions. I've already adverted to that when I talked about autonomous or unilateral sanctions. Autonomous, of course, sounds much better than unilateral. Unilateral sounds, well, it sounds unilateral. As I've said, the EU doesn't use the term economic sanctions. If you go to Article 215 of the Treaty on the Functioning of the European Union, it uses the term restrictive measures. That's the EU term. Another term you sometimes see bandied about is unilateral coercive measures. It's a term that's been adopted within the UN. It's to refer to autonomous or unilateral sanctions, and you see it in a number of a series of General Assembly resolutions and a series of resolutions of the UN Human Rights Council condemning states' use of unilateral coercive measures. So where you stand determines the terminology you use in this case. And the fact that the terminology is contested tells us that the legality of sanctions, or at least the rules governing their legality at the international level, is also contested. How long have I got? 10 more minutes, I think. I'm only on slide 1. It's alarming. Finally, this is a historical thing. What we've seen in recent decades, and we've seen this at the first of all at the UN level, is a shift in the sort of sanctions that have been imposed, from so-called comprehensive sanctions to so-called targeted or smart sanctions. Comprehensive sanctions, the idea is they are about a complete interruption of economic relations with a targeted country. Now, we saw that against Iraq following the invasion of Kuwait in 1990. Very controversial. And it was said, and there's a Lancet study in the Lancet on this, that the sanctions imposed on Iraq caused the death of several hundred Iraqis. So it's in terms of excess mortality because of lack of access, because of an embargo, economic embargo, lack of access to foodstuffs, to medicines, and so on and so forth. In addition, what we saw at the time was a belief that comprehensive sanctions weren't very effective. So they were destructive. They caused widespread harm and suffering among the Iraqi civilian population, but they didn't do much to target those responsible for Iraq's bad behavior, the leaders of the regime, the Ba'athist leaders, Saddam Hussein, his family, his entourage. So there was a move both for humanitarian purposes and for purposes of effectiveness towards what were called smart, or more often now targeted sanctions, which sought to target particular individuals or particular entities who were seen as most responsible for the situation which sanctions were meant to address. Now, there are two things to be said there, I think. The first is what's interesting about smart sanctions is it's tended to be a reference to, when people think about it, it's been a reference to individuals being targeted in two ways in particular. One is in terms of asset freezes, so that their states have been required to freeze their assets to prevent them using their financial resources, in particular, to stop others dealing with them, entering into economic transactions, financial transactions. And indeed, with regards to travel bans, preventing these individuals traveling. Now, under UN sanctions, all member states are obliged to freeze a designated person's assets and to prevent them from traveling, prevent them from entering their territory. Obviously, if such measures are imposed by one state or by the EU, they can't have such a wide ambit. But even with smart sanctions, with targeted sanctions, designation of individuals and designation of entities as subject to asset freezes, travel bans, has not been the whole story. Other common types of sanctions are arms embargoes and various forms of import and export bans, restrictions concerning specific sectors of economic activity, so I've said import or export bans, investment bans, prohibitions on supplying certain goods or services, and so on and so forth. And if you look at the various packages of sanctions against Russia adopted over the last 18 months, you can see that targeted sanctions can end up being pretty broad. That's the first thing. So it's wrong to concentrate just on designated or targeted individuals or entities. The second thing, and I'm going to mention this now, is that if you look at this, practice really starts at the UN level. If you look at the UN, first of all, targeted sanctions dealt with individuals or entities associated with the government of particular states, or at least the government, or at least with regards to particular entities that were essentially acting as the government, or acting as government. So the first two UN targeted sanctions were against the then military junta in Haiti and the leaders of UNITA, which was one of the factions in the then civil war going on in Angola back in the 1990s, but was really acting as a government. It had control of territory and the people within it. But what happened then is, once you go after individuals, you don't need to go after states. It's not a necessary corollary. And targeted sanctions started being used against individuals who were not associated with states, but with particular organizations, particularly criminal organizations, terrorist organizations. So from resolution, it's what, 1268, isn't it? Am I right? You get sanctions against persons who are seen as, who are said to be associates or members of Al-Qaeda. More recently, we've seen sanctions against various forms of criminal enterprises, not just terrorists. So persons engaged in crypto crime, and indeed, straightforward criminal activity like the Kinahan organization, which is an Irish criminal gang based out of Dubai, which the US has recently sanctioned. So we've got various types of economic sanctions, and they can be imposed against all sorts of persons, all sorts of groups. I've got I suspect about 5 minutes. So what else can I say? We go to the next slide. Go back one. Just to say very briefly about the United Nations. The legality of UN sanctions as a matter of international law is fairly uncontested. Members of the United Nations are obliged to accept and carry out decisions of the Security Council, decisions of the Security Council, Article 25 of the Charter, decisions of the Security Council trump member states' other international obligations. That's implicit in Article 103 of the Charter. And then you find in Chapter 7 of the Charter that the Security Council, if it determines the existence of a threat to the peace, a breach of the peace, or an act of aggression, which terms are not defined in the Charter, can adopt measures, either forcible measures or, for our purposes, non-forcible measures, which may include complete or partial interruptions of economic relations, i.e. economic sanctions. So the Security Council can adopt sanctions and they're binding on all the member states. That's simple. What about the at the EU level? At the EU level, I'm not going to say much about Article 215 because I'm going to leave it for Francesca, but there are specific provisions in the Charter concerning the adoption of restrictive measures with regards to third countries, that is non-member states. And I'm not going to deal with this, but you should also look at Article 75, which covers actions to prevent or combat terrorism. So the EU, under its constituent treaties, has the power to adopt economic sanctions. Now, it's important to remember, I think, and I said this at the beginning, one of the issues is that as regards autonomous or unilateral sanctions is how they fit in a wider international law context. Now, if you look at Article 21 of the Treaty of the European Union, what it tells us is the European Union's action on the international level shall be guided by the principles which it inspired its own creation, development, and enlargement, blah, 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 which include the rule of law, the universality and indivisibility of human rights, and respect for the principles of the UN Charter and international law. So the EU is, and this is, within its own constituent instrument, even excluding what international law might require to it, bound to respect international law and indeed human rights. It's important to remember economic sanctions, particularly, and then we come back to targeted sanctions, targeted because they can target individuals, are bound to respect international law, both on the interstate level, but also international law as it affects individuals, that is international human rights law. We'll come back to this. This has been an extremely controversial area in the last couple of decades, really since 9/11. In the EU, it came to the fore in particular in litigation before the Court of Justice, the European Union, in the Cardi case. Mr. Cardi had been subject to EU restrictive measures. His assets had been frozen. He was subject to a travel ban. He sought to challenge that, first of all, before the Court of First Instance, as then was now the General Court. And then the matter was appealed to the Court of Justice. What did the Court of Justice say? It said this: all community acts must reflect fundamental rights. Now that's a matter of, now we'd say all union acts must reflect fundamental rights. That's a matter of EU law. One of the interesting things about Cardi was he was subject to restrictive measures because the Security Council was implementing a decision, because the EU was implementing a Security Council decision. The argument was the member states are obliged to implement the Security Council decision, and therefore questions of fundamental rights fall away. The Court of Justice said that's wrong. You have to look at the act implementing the decision of the Security Council. That is a union act, and union acts must reflect fundamental rights. So as a matter of EU law, even putting international law to one side, human rights must be, in EU law, fundamental rights, but it's the same thing really, must be respected. The next slide. I'll skip that because I know I've got less time. I'll just say this very briefly. What we have at the moment, why everyone is so interested in economic sanctions, is primarily the unprecedentedly wide sanctions imposed, but not just by the EU, but also by a number of other states, the United States of America, Canada, Australia, the United Kingdom, etc., in relation to Russia's aggression against Ukraine. Now, there has been a number of critiques. Now, those are autonomous or unilateral sanctions. Why? Because the Security Council is unable to act because Russia has a veto in the Security Council. But those sanctions are justified on the basis that states adopting them are acting to enforce international law. There's long been a critique, in particularly the United Nations, that state that autonomous or unilateral economic sanctions are illegal because they are coercive. They seek to coerce states, and there is the states against whom they are directed, and there is a prohibition of coercion in international law. We go to the next slide. Now, there are really, I think, three ways to justify autonomous or unilateral sanctions. They are essentially, one, they're necessary to avoid the state imposing them, undertaking an illegality itself. Won't deal with that. Secondly, they're not prohibited under international law. I think that's certainly true with some forms of sanctions. Travel bans is a good example of that. By and large, states are not obliged to allow the nationals of other states into their territory, absent certain exception. Asylum seekers, for example, if they can't expel them until they've determined whether they are refugees or not. But in general, you don't have to allow foreign nationals into your territory. But the final reason is that unilateral autonomous sanctions can be justified, even if they would be generally unlawful, because they are what's known as countermeasures, third-party countermeasures. They are seeking to encourage compliance, to put it neutrally, with international law. They are responses to illegal acts by the states which are targeted by them. Final slide. Now, I'm not going to go through the various justifications on the legality of sanctions, but the one here that's important is the final one, which says simply this. There are some states that say the only institution that can impose economic sanctions is the Security Council. It's famously the position taken a few years ago by Russia and China. You can see why they might think that. I don't think you have to be overly cynical to see why, to think why two members of the permanent member Security Council might be in favor of that view. There is, however, another view, which is you can still accept that there exists an international community. You can still accept that there are values which states have committed to respect. But if the international community, as represented by the Security Council, the United Nations, can't act, then states can act autonomously, or if you prefer, unilaterally, to encourage law-breaking states to come back into compliance with their international obligation. That is very largely, I think, the view that is taken as regards sanctions against Russia at the moment. Do I have one final slide? Got one final. I'll conclude with just saying a few very introductory things then, before turning over to Francesca, about EU restrictive measures. I think the EU, when it adopts economic sanctions, vis-a-vis third states, usually purports to place itself in that category. It's acting to enforce international law. I think practice particularly since last year, actually supports the argument that states are entitled to do that, that is a lawful thing for states to do. What that does mean, and we'll come back to this, is it means that the EU can't just rely on sanctions being lawful as a matter of EU law. It's a stance that places a premium on sanctions lawfulness as a matter of international law. Traditionally, the EU has placed less emphasis on legally justifying its sanction practice externally than it has internally. But I think it needs to do both. But anyway, I've slightly overrun, I know, apologies. I'm going to hand over to Francesca to continue.
Okay, thank you for the introduction. I will now focus on a specific question, which is the following: who is responsible to comply with EU sanctions? So in my discussion, I will then focus on EU restrictive measures, also most commonly known as EU sanctions. And
sorry, Francesca, could you please speak closer to the microphone?
Yes.
Much better. Thank you.
Much better this way?
Yes.
Okay, perfect. Focusing on targeted sanctions, and so as a very specific form of targeted sanctions, in particular asset freeze measures, I would say that there are two main obligations under EU law, and the standard wording is the following. So all funds, all economic resources shall be frozen if they are owned, controlled, or held by a designated person. And secondly, no funds, no assets, no economic resources shall be made available to them. And this provision actually does not tell us much about who are the addressees of these obligations. Differently from the anti-money laundering directive and the anti-money laundering legal framework, where we actually have the directive saying this directive shall apply to the following entities, the so-called obliged entities. For sanctions, we do not have a specific list of obliged entities. So the question is everyone involved in the implementation of sanctions? Well, the Union, and in particular the soft law guidelines of the European Union, confirm that EU restrictive measure shall apply only where we have a link with the Union. And again, we have a standard wording in every regulation saying the regulation shall apply to the territory of the Union, to aircraft, vessels, under the jurisdiction of the member states, but also to any EU national, any legal person, company that is incorporated or that is registered under the law of a member state, but also to anyone who is doing any kind of business in the Union, in part or in whole in the Union. And again, the EU best practices help us, as a soft law measure, help us to understand what is the role of economic operators and citizens. So again, here we have a reference to all persons, all entities subject to the EU jurisdictions are obliged to inform the competent authority to any information at their disposal which would facilitate the application of EU restrictive measures. So we also have a clarification, and again a comparison with anti-money laundering, because here the Union says sometimes sanctions may impose obligations on the economic operators that are similar to the anti-money laundering ones, in particular knowing your customers and refraining from autonomous transactions. But the Union also clarified that sanctions may create additional obligations, so perhaps they are much more burdensome for operators and citizens. Essentially, I would say what are the duties of EU actors? So first of all, the duty to inform, cooperate, report any information that would facilitate the application of sanctions, which is first of all help in the identification of designated person, assess ownership and control, not an easy task, then a duty to freeze assets in case of a positive identification, and then obligation not to make funds available. But also, if an even more difficult obligation, the one concerning circumvention, so detecting and reporting circumvention. And then the question will be, but yes, but what if they do not report? What if they do not inform competent authorities? Well, under the EU law and the regulations, again, we have a standard clause, and the standard wording affirms a non-liability clause. So differently from other regimes where there is strict liability for operators, economic operators, under EU law, we have a specific provision affirming that the actions by national legal persons shall not give rise to any liability if they did not know or they had no reasonable cause to suspect that they would have infringed the regulation. So no strict liability, but I also wanted to mention a case of the court of 2015, where actually the court clarified that the context shall not be overlooked. So essentially the court says when the context is so clear and there is a growing suspicion concerning certain transaction, the case in particular was about European bank based in Hamburg dealing with the Iranian prohibited transactions. And in that judgment, the court says, well, the European bank could not have been unaware of dealing with transactions that are actually prohibited under EU law. So the context is extremely relevant when it comes to the assessment of the liability. And ultimately, before ending the session, the first panel, I also wanted to look at the question, so who is responsible, who does the Union trust in the implementation of sanctions in war times, so in the last few months. So first of all, I wanted to highlight that here I would focus on Council Regulation 269. I would say regulation dealing with so-called Russian sanctions. The reporting duties are extremely broad, and that's why I call them extended reporting duties. Here it's very dense, but it is precisely the provision, Article 8, relating to reporting duties. And as you can see from the slide, actually, there are many obligations for economic operators and EU citizens. So information about frozen funds, funds owned or controlled by designated person, but also funds that have not been treated as frozen by other operators, or funds that have been subject to movements, suspicious transactions within the 2 weeks before designation. So extremely broad reporting duties, but what is also new, and it's first time we see in EU regulation, is that also listed individuals have reporting duties. So let's say Russian oligarchs or Russian targets, they are actually subject to information duties, reporting duties, and they are subject to self self-reporting obligation about the funds, assets, economic resources they have within the European Union, which is actually quite unprecedented. So the question is everyone involved in the in compliance? Well, everyone, yes. Also, I wanted to mention the whistleblower tool, a new tool to directly communicate with the Commission, the European Commission, if we are aware of any violation of circumvention of EU sanctions. And here is just a screenshot of the official website to make reports. And from the wording of the website, we actually have a clear reference to, let's say, everyone, because it says, by voluntarily providing us with information about EU sanctions, you can help us. So you can make a report. And again, there is a stretch interpretation of reporting duties, and it seems that everyone is involved. And I would conclude saying, well, we have seen many reporting duties according to standard clauses in EU regulations, but also here we have new rights. And my ultimate consideration would be, it is not clear in war times what are the reporting duties and the reporting rights, because here the whistleblower tool has increased the opportunity to report, but it has not clarified what is the relationship between the duty for economic operators and EU nationals to report and our rights to do so. So we thank you very much. This is the end of the first panel. We will be happy to reply to questions and to comment further. So please.
Yes, I think we've got, Francesca was extremely fast there.
Because I
so we've got plenty of time. Are we meant to be having a 10-minute break, or are we going straight through to the next session?
No, we are meant to be.
We are meant to be having. Well, if anyone's got any questions, now is the time to ask them.
Let me just remind that for question, you can leave the question in the chat so as we can read them. And you can do also in the due course of the entire training.
I don't see anything in chat at the moment.
There is a hand raised by Mr. Anastasio, who can intervene if the microphone is open. Otherwise, please write a question in the chat.
Thank you both, Professor and Francesca Finelli, for your interesting presentation. I wanted to ask you a precise question, I would say, on the legality of EU restrictive measures under international law. I've wondered it, I've researched it a little bit, and you know, I am not quite. I wanted to ask you whether you have correctly said that the EU placed itself in the third category that assesses that restrictive measures may be correct, may be legal, even though the state is not directly offended by the conduct of the third state, and to an obligation which is erga omnes. But I wanted to ask you if, in your personal opinion, if you were the International Court of Justice, if you were called to tell your opinion about the legality of the intervention of the autonomous sanctions by a regional actor, what would be your opinion in this regard? Meaning, if you would agree with the right by a third party, which is not offended directly by the conduct, to impose some consequences, or if you agree that this would go against some principle of the international law? Thanks.
Well, shall I? I'll take that one, shall I? Well, I'm always a bit reluctant to put myself in the shoes of the International Court of Justice. They've never had a Luxembourg judge, and I suspect they're very unlikely to have one in the foreseeable future. But I think there are two things to say. First of all, of course, the court did, in the Nicaragua case, say that states aren't obliged to maintain economic relations with other states. So it is an attribute of sovereignty, I think, for states to determine what their economic relations with other states might be. Now that, of course, is not an absolute answer, because that's just an answer under general international law. We're now in a situation, of course, where matters are very different. Almost all states are members of the World Trade Organization. Almost all states are parties to bilateral investment treaties. So there can be a network of treaty obligations that come in. But going back to general international law, I think it is, although it was one of the more controversial parts, although the provisions on the invocation of state responsibility by third states was one of the more controversial aspects of the ILC's articles on state responsibility. And although famously the ILC articles don't actually say whether countermeasures by third states in response to erga omnes breaches are lawful, I think that increasingly state practice argues for their lawfulness. And therefore, I think the International Court of Justice, although I suspect the judges would not, in fact, I'm pretty sure the judges would not be unanimous. I think they would uphold the legality of third state sanctions in response to erga omnes breaches, such as breaches of the prohibition of aggression, actions against the right to self-determination, widespread and systematic human rights violations. Providing, can I just say one thing? Providing, of course, that those responses were, one, proportionate, and two, not otherwise in breach of the various rules of international law that you can't breach even when undertaking countermeasures. Francesca, sorry.
No, I just wanted to add a very short comment, but last week, on the 13th actually of September, the Court of Justice released the judgment on merits of the Venezuela versus Council case.
Read that, yeah.
And the court, actually dismissed the action, and it is on very interesting. I think on the fourth point, the court did not qualify EU restrictive measures as countermeasures under international law. So perhaps the court is also illustrating sanctions, EU sanctions, as a different category, a different box of international law, not fitting in the countermeasures.
Well, I think it's perfectly possible that a restrictive measure is not a countermeasure, because I think that, as I said, there are certain things that states can just do.
Like
a countermeasure, a countermeasure is by definition a measure that would be illegal if it were not a countermeasure. But the problem now, I think, is that there is a lot more, states are now pretty enmeshed in a network of particularly treaty obligations in the economic level, and in many respects failure to comply with those can only be justified as a countermeasure. I think, and to be honest, I think most asset freezes must be countermeasures. But it can get tricky because, of course, as I've said, it's perfectly possible to have to designate a person who's not associated with a state. We've got another question.
There's a question in the chat, which asks, do you have data? Yeah. Do you have data about the restrictive measures in terms of money that was blocked? So I also, in case, ask Giovanni and you to intervene, or yeah.
I think that would be better. We're just lawyers. We don't do statistics. There is definitely data on it, but I don't have it in my fingertips.
I don't know, Giovanni, would you like to intervene? I guess that some of the speakers this afternoon will also provide some highlights, some data, but please, Giovanni.
Yeah, the latest public statement that we have about this topic said that for what concern the assets of sanctioned individuals and entities, they amount to 19 billions of euros. Then, of course, we have all the assets that have been frozen from the Russian central bank, with the amount of more than 108 billions. So these are the latest public figures that have been provided at May 2023. Of course, that will be individuals that will be sanctioned, and then new assets will be frozen. But apparently, these are the latest figures. So about 200 billions of euros have been frozen so far in consequence of sanction against Russian individual, Russian central bank.
And of course, we've also got to remember that although it's the we've had they're the most comprehensive, let's put it that way, sanctions. They're not the only ones by a long chalk. They're not the only restrictive measures which the EU has adopted.
Shall we have a break?
I think,
Yeah,
I think we should have a break to allow everyone. Well, just you can do what you want.
Let's reconvene the meeting at 10:35.
I think.
Okay.
Yeah. All right, and then Francesca's going next.
Yes.
Thank you very much then, and we'll see you then.
So good morning, welcome back. Welcome back to the training. I will start with the second panel, which actually was supposed to be the third panel, but we swap panel. Okay. Panel 2 and 3. Okay. So I hope you can all see the screen and you can hear me well. Can you just confirm it?
Yes.
Well, I cannot
Francesca,
see
we can listen to
the
you.
chat, so I will just proceed. If there are any issues, please interrupt me. So I will dedicate the second part of the discussion to violations of EU restrictive measures and circumvention. And I will specifically focus on circumvention because I believe it's much difficult to understand, to grasp as a concept, and to also see the legal challenges that are all around the circumvention problem. And the objective of my discussion is to address the following questions. So, what is circumvention? How the Union respond to it? And then I would guide you through the recent developments after Russia's invasion of Ukraine. In particular, I would look at the legislative proposals for the harmonization of criminal law and penalties. So starting from the basics, so what is circumvention? Why is it a problem? So we have seen with Matthew before that we have different kind of sanctions, and in the past we had comprehensive embargo and very comprehensive restrictions. So circumvention was not much of a problem, but now that we have very targeted sanctions and very specific, narrow, precise measures, then circumvention as a problem. And again, another feature of circumvention is that we do have, as already explained before, we do have usually unilateral, autonomous sanctions instead of collective sanctions, because we have seen that UN Security Council not always is not always able to adopt sanctions because of the veto powers of some member states. In the case of Russia, it's pretty clear that we cannot have collective sanctions imposed by the UN Security Council against that state. So again, here we have EU sanctions which are unilateral, which are targeted, and so circumvention becomes a real challenge precisely because of the design of EU sanctions. But circumvention is not something new. As EU sanctions, they are not just EU sanctions against Russia. So what is circumvention under EU regulations? Well, we do have a standard clause, a clause that I would say is the anti-circumvention clause, which in all regulations and decisions, Council regulation, Council decision imposing sanctions, it prescribes that it is prohibited to participate knowingly and intentionally in activities the object or effect of which is to circumvent, is to frustrate the objectives of EU sanctions. So it is a very short but also dense provision, knowingly and intentionally. So we do have two subjective elements, the knowledge and intent. According to the Court of Justice, these two elements are actually interpreted very broadly, meaning also the knowledge and the acceptance that the activity can lead to a circumvention of sanction. And then activities which have specific and concrete effects, but also potential effects of circumvention. So it is not needed to have the concrete results, but also abstract, hypothetical, and potential results of circumvention in order to punish that activity. I also wanted to show you different clauses and perhaps do a bit of a comparison between EU sanctions, but also UK and US sanctions. So under UK sanctions, we do have, again, an anti-circumvention clause, a standard clause for all different regimes. And again, we have reference to participation in activities which have the object or effect to circumvent sanctions. Here we have a specific reference to intention, so intentionally participate in activities. When it comes to the US sanctions, what I find very interesting is that we do not have just one standard clause, but we have different standard clauses. So there is a specific reference to evasion, but also to a specific concept under US law, which is causing a violation. So it is prohibited to conduct transactions that evade, avoid, have the purpose, or can cause a violation of US provisions. And another clause under US sanctions law is that we have the prohibited facilitation. Again, there is I would say, very specific emphasis on the US sanctions law against circumvention. Then, having said something about the legal terms, I want to address some examples of circumvention. It is plenty of examples, and precisely because circumventing is it's also a creative activity. It's difficult to define de facto what are the elements of circumvention, but I wanted to give you some examples. So in particular, focusing on the latest events and Russian sanctions and circumventing attempts by Russian oligarchs, Russian legal entities. So the US Financial Crimes Enforcement Network issued alerts, and they are very interesting because they also very clearly state some red flags, such as the use of corporate vehicles, complex corporate structures, shell companies, legal arrangement, trusts to obscure the ownership of funds, of assets. The use of third-party intermediaries, it's also one of the red flags. In the case of Russian oligarchs, there are also specific red flags in relation to real estate, the use of luxury goods, precious materials, and high-value assets, vehicles, yachts, and so on. Additional red flags, again, from the US side, a very interesting report about the trends of circumventing attempt. And then looking at let's say, multilateral response to circumvention, I wanted to highlight the REPO task force, and it was already mentioned before. So REPO is a multilateral task force which brings together EU, but also US, UK, but Australia, Canada, Japan. So a very multilateral effort to counter circumvention. And in an advisory note in March 2023, it lists which are the patterns and the most used ways to circumvent sanctions. First of all, the use of family members, close associates to ensure the continued control of assets. So we have transfer to children, spouses, briefly before designation or immediately after the designation of individuals. Again, we have the use of real estate to as a vehicle to hold Russian wealth, and the use of trust, the use of corporate structures, and also the use of enablers. So the use of professionals and the ability to, for instance, open bank accounts, receive money, use third country jurisdictions. And I also wanted just to mention concerning the use of complex corporate structures, a recent study by Transcrime, precisely focusing on firms, European firms controlled by sanctioned oligarchs, Russian oligarchs. And I would not illustrate the report, also because I was told that it's under let's say revision and the data will be updated soon. But this study inside the Matryoshka is extremely interesting, and it's plenty of numbers when it comes to controlled firms by Russian oligarchs subject to sanctions. More recently, a few days ago, also the Europol and the European Commission issued very interesting studies. The European Commission also listed in this guidelines for EU operators, listed some circumventing patterns. And here again, we have indirect transactions, the use of intermediaries, shell companies, but as you can see, it's a very long list. It's also concerned the trade and export circumvention, which is something that we do not touch much in the training, because we do focus on individualized sanctions in the form of asset freeze. So, having clarified what is the problem, how it is addressed. Now we will see how the Union responds to it. And I would now structure the response of the Union in 3 points. So the use of designations, implementation of sanctions, and enforcement. So what is the first tool that the Union has to respond to sanctions? Firstly, we should look at how sanctions are designed. So the sanction design, and in particular, the design of designation grounds, is the first tool to address circumvention. Because if we have very targeted designation grounds, then it's extremely easily to circumvent sanctions. If we just have, for instance, all funds of Russian oligarchs shall be frozen, then not being a Russian oligarch, it's easy to be, let's say, a vehicle for circumvention. So the way sanctions are designed, it's already the first factor for understanding what is the response to circumvention. And I wanted to mention some designation grounds that have a specific reference to circumvention. Here we have 3 different regimes: North Korea, Iran, and Libya. And here we have a specific reference to person assisting in the evasion. So those persons shall be listed. In the Iranian regime, we also have reference to evasion or assisting a listed person to evade sanctions. And ultimately, in the Libyan regime, we also have reference to assisted circumvention. Then going to the Russian sanctions, so the Council Regulation 269, as recently amended. So under Article 3, which lists all the designation criteria, we do also have a specific autonomous designation criteria, which is precisely dedicated to circumvention activities. And here we said that national and legal person that facilitate circumvention shall be listed, but also persons that otherwise significantly frustrates the provision of the regulation. So very broad scope of application. But what is fun is actually funny to notice is that we do have just one specific designation which is based on that designation criteria, and it is added in June. It is about a Russian-based entity involved in circumvention of sanctions with a EU-based entity. In particular, we do have a Dutch court conducting investigation, criminal investigation on smuggling of semiconductors to Russia. So we do have a criminal proceeding going on at national level. And for this reason, we also have a listing concerning circumvention. But we do not have any other specific designations, to my knowledge, that are based precisely on the letter H, so that specific designation criteria. So why? Why we should question, like, what is the standard of proof for those designations? What is the standard of proof for circumvention under EU law? So looking at the past, I would suggest to look at what the European Court of Justice said about previous designations that were based on the circumvention ground. So we do have different judgments from the Iranian regime. So we had different entities, legal entities, challenging their designations. We have Sharif University of Technology, the Central Bank of Iran, and the Iranian shipping lines that in the past challenged their first designations. And their designations, what they have in common is that they were all based on facilitating circumvention of EU sanctions against Iran. And what happened is that the Court of Justice annulled all the designations, so they are all successful stories for the applicants, because the court says, well, the circumvention criteria is actually insufficiently supported by reasons. So the reasons, the statement of reasons are extremely vague. There is no factual evidence. There is no clear indication of what are exactly the allegations concerning the applicants. So all the cases listed here, they were successful for the applicants, and that's why the council then decided to relist those entities, but under other grounds, stressing different criteria, not the circumvention one, which is actually difficult to prove in front of the court, but other grounds such as the notion of support, financial support, material support. So the lesson learned from the past and from the case law of the Court of Justice is actually that listing a person or an entity for circumvention activities, it's not that easy. And that's why Council Regulation 269 has not only a letter H that we saw for circumvention, but we also we should also stress another designation ground, which is letter G, which concerns not only oligarchs, the leading business person operating in Russia, but also their immediate family members, for instance, or persons that benefit from them or that are in any case associated with them. So here, since it would be difficult to prove circumvention attempts, the council decided in June precisely to add an autonomous designation grounds for family members. So just the fact of being immediate family members that are involved in specific economic sectors, that they are associated with Russian leading business person, it's enough to be listed, and it is enough to be defended before the court. And actually very recently, so a few days ago, the Court of Justice dismissed the actions for annulment of several family members. Here you have the spouse, the son, and another spouse of Russian oligarchs, in particular Pumpyansky and Timchenko. So here we can see that family members, they have not succeeded, even if probably the ultimate reasons why they were listed is precisely to block circumvention attempt. Now, moving to implementation. I briefly mentioned that in the implementation process, the union is much present. So here is just a summary of what I have already illustrated. So I will not focus too much on this part. So I just wanted to mention that the EU responds to circumvention by imposing very strong reporting duties, and the extended reporting duties are those contained in Regulation 269, Article 8 and 9. Then we also have reporting rights since March 2022, and the introduction of the whistleblower tool for directly reporting sanctions breaches or circumvention attempt. When it comes to the multi-level dialogue, we also have a strong cooperation among private sector, national competent authorities, the European Commission, in particular DG FISMA, who is doing a very challenging but also hard work in coordinating the different actors involved in the implementation of sanctions. And more recently, we have the Freeze and Seize task force precisely dedicated to enhance cooperation among those different actors. And in the case of Russian sanctions, we can also see that this cooperation, this dialogue is supported by the extensive FIQs that are published by the Commission on a regularly basis. We have, I checked yesterday, we have around 342 pages of FAQs just concerning the Russian regime, so Regulation 269 and Hate 33. And so the Union responds to the Convention with all this implementation effort. But now I would like to focus for the last few minutes on the enforcement effort. So, what is the standard clause for enforcement? So, in all regulations imposing sanctions, we have a standard clause which traditionally ask the member states to design their own enforcement rules, their own penalties. The only requirement is that national penalties must be effective, proportionate, and dissuasive. So there is no much, there is no further guidance on this, and member states were free to adopt penalties under administrative law, criminal law, and so here we have a clear table showing the fragmentation at the national level. So we do have member states, some of them, for some of them, the violation of sanction is either criminal or administrative offense. So we have a double track. This is, for instance, the case of Italy. But then in other states, violation of sanctions has always been a criminal offense and criminal offense only, such as in Luxembourg, for instance. And in 2 member states, violation of sanctions was only administrative offense. So the European Commission has never interfered, the Union has never interfered in the enforcement, but precisely because we have seen unprecedented use of sanctions, we also witnessed the unprecedented intention to harmonize the enforcement and to avoid this very fragmented approach. And here I would like to conclude with the recent developments and the legislative proposal to harmonize actually enforcement rules, in particular rules of criminal law. So for the recent developments, here I wanted to show you that actually, because of Russia's invasion of Ukraine, we can see that there are context-specific reforms that are precisely related to the war and the Russian sanctions, and other reforms that are more structural, so permanent, and they will impact EU sanctions more generally. And I also wanted to, let's say, advertise a piece, a contribution I wrote on this, precisely on the comparison between context-specific and structural reforms. And some example context-specific reforms, the Freeze and Seize Task Force, precisely dedicated to Russian sanctions, the reporting duties, precisely dedicated to Regulation 269. But then we also have structural reforms, such as the whistleblower tool, or more interestingly, the reforms concerning enforcement that I'm going to illustrate. So the turning point, I would say, it's the 25th of May 2022, where the European Commission put forward an unprecedented proposal, a 3-step proposal, where the final goal is to harmonize the enforcement of sanctions and impose common criminal rules for all the 27 member states. But in order to reach that goal, these are the steps that the Commission proposed. So first of all, a proposed Council decision to extend the list of Eurocrimes. So as you may already know, according to the treaties, Article 83, TFEU has a list of Eurocrimes, which also includes terrorism, anti-money laundering, corruption, and so on. But the violation of sanctions was not in the list. So in order to harmonize under criminal law rules, the Commission had to adopt the Council, to propose the Council decision to extend the list of Eurocrimes. A second proposal on the same day, proposal for a directive, so harmonizing criminal penalties and rules and definitions under EU law. And third step, which is also much relevant for our discussion, is a proposal, a new directive concerning asset recovery and confiscation. So this is an escalation of regulation. So if we do have a new Eurocrime, we will then be able to harmonize it, and we will then be able to use confiscation against proceeds of those crimes. So this is what happened. So since 25th of May, we actually had the EU institutions working very hard and very fast, I would say, on the proposals. So on the 28th of November, the Council approved with unanimity the introduction of a new Eurocrime, with also the support of the European Parliament. So the violation of EU restrictive measures, including circumvention, it has become one of the EU areas of crime, so serious areas of crime with a cross-border dimension. So we have a new Council decision amending or supplementing the treaties, and few days after, on the 2nd of December, we have a new proposal for the commission, from the Commission, precisely on the harmonization of criminal rules and penalties. So we have a new proposal for a directive. And at the moment, I can just show you a bit how the proposal, just in like few minutes left. It is interesting to see that in Article 3, the proposal lists what are the criminal offenses and that should be harmonized. And we do have circumvention among those criminal offenses. And although the directive is under negotiation, we already know that there are some areas that are considered circumventing offenses, such as concealing assets, providing false or misleading information about the identity of a designated person, or the ownership of control of their assets, failing to inform the authorities, failing to cooperate with the national authorities. And at the moment, the EU institutions are actually negotiating the content of the directive. So negotiations are in process and in progress. So we will then see how exactly circumvention will be defined and how it will be punished. So I cannot say much because everything is under discussion. But what is clear is that there is a strong push forward, harmonization, criminal penalties, imprisonment, and I would say very significant fines against individuals participating in circumvention activities. So I thank you very much. I hope I have stimulated a bit your interest in this. I also wanted to put a reference to a contribution I wrote precisely on the topic of circumvention and the EU response. So I think that I touched several points I wrote in the article, but it's still available online. So feel free to check it. I will now stop sharing, and I will give back the floor to you, perhaps to questions, and I'm happy to discuss further. Thank you. And we should have 10 minutes for the Q&A session before the break.
So there is a question from Lorenzo Bodrero. do you or any speaker here have any assessment about the
Okay, so we
effectiveness
do
of
have
sanctions
first
against
question.
enablers?
Should I
So
address the first question? What do you think?
yeah, please go on. Matthew as well, if you want, and I ask also my KLEPTOTRACE colleague if I want to intervene. But please, Francesca, start.
So we do have question regarding the assessment of sanctions effectiveness against enablers. And so here I would say that you touch very sensitive topics, like first of all, effectiveness of sanctions, like what do we mean exactly by effectiveness? This is difficult to define, and also enablers, like there are different kind of enablers of sanctions evasion. So I would say that there are different responses. If by enablers you do mean family members, associates, then I would say that amending the designation grounds, it's something that can help the council, the union, to respond to circumvention, adding designation criteria. So if I am, let's say, the daughter of a Russian oligarch, now the council can directly list my name as immediate family member associated with a Russian oligarch. Same for a associated person, not even not family members. Enablers, well, it's interesting if you think about legal professions. So in that case, we cannot list, according to the current regime, we cannot list, let's say, lawyers helping Russian oligarchs, helping to circumvent sanctions. That would be actually something that can be punished and enforced under national law, and in particular probably in the next future under the new directive with which concern criminal definitions and penalties for the violation of sanctions. But again, it must be then proved that there was the intention to circumvent sanctions by providing, for instance, legal aid, legal assistance, legal services to specific designated person, let's say oligarch, with the intent to evade sanctions, EU sanctions. And actually, for me, the best examples, the easiest analogy is tax and sanctions. So in tax we do have a clear distinction between tax evasion and tax avoidance. Tax avoidance is something that is pretty permitted, legal, and you can also ask for advice to avoid some kind of taxes. But tax evasion is clearly something criminally illegal. In the case of sanctions, what was missed is like this specific distinction between avoidance and evasion. So, for instance, precisely now the point is addressed by the EU institution in the negotiations of the new directive. So, how to define avoidance of sanctions? Is it evasion? Let's say all categories of sanctions avoidance, do they fit in the evasion definition or not? Shall be prosecuted or not?
Thank you, Francesca. I don't know, Giovanni or colleagues, if you want to intervene on the same issue.
Yes, of course. I say, can you hear me? I think you can. So that I have noted about the extent, for instance, of how many assets that have been frozen so far were directly,
Yes,
owned by.
we do have an additional point on this, precisely on the role of auditors, where their auditors can enable circumvention. Yes. So I would say good point. I would say that they cannot. I mean, they could be designated enablers under letter H, again, of Regulation 269, but it's difficult. I mean, it may be difficult to have a sufficient standard of proof for then defend the designation before the Court of Justice, if ever challenged before the Court of Justice. My opinion is that now with this huge emphasis on enforcement, criminal enforcement, national prosecutions will also increase, and then that will be for the 27 member states to actually set new standards and new also emphasis on the prosecution of enablers of circumvention. We do have new, I mean, some prosecutions going on. For instance, the one I mentioned about the Dutch authorities is just one example. So I do think that also legal professions, auditors and enablers, as you were mentioning, can actually be asked an unprecedented due diligence in dealing with designated persons, and also in detecting circumvention attempts. No, I cannot hear you. Oh, wow.
Perhaps, yeah, Francesca, you cannot hear us.
Now I can hear you. Oh, sorry. I'm so sorry.
No problem. No. We are managing the question. Giovanni was also answering regarding this question on the auditors, so and the enablers. So please, Giovanni, I give you back the floor.
Yeah, thank you. And so I was saying that actually we have no detailed information, for instance, on the extent of, for instance, how much of the assets that have been frozen were directly linked to the sanctioned individuals, or they were indirectly linked to the sanctioned individuals, for instance, because they were concealed by opaque entities or by the use, professional and other enablers. And we think that this is a key issue on the capability to trace these assets. And indeed, in these 2 years of project of KLEPTOTRACE, we would like to review all the cases that actually come out that identify the fact that a sanction circumvention indeed also is helped by the use of this professional, but also with we would like to develop a tool that, combining different sorts of information, allows to do some kind of investigation to understand, for instance, the extent to which all the networks related to these sanctioned individuals also may conceal the assets that at the end may be under the availability of the sanctioned entities. And so we think that this is a very topical point, the necessity to improve the capability of intelligence of public authorities, and the tool that we would like to develop also try to address this problem of enablers and all the techniques that may be used to conceal the direct availability of these assets by sanctioned entities. I wanted just to say that.
Sorry again, Giovanni.
Don't worry.
So any more questions from the audience? Not see more questions. So I guess that can continue. Perhaps I suggest we can continue with the panel, the last panel before lunch, if it is okay with you, and maybe we can break a bit earlier before lunch. Is it okay?
Yes, on my side it is fine. Can we have just 5 minutes break, and then not the 10 as planned, but maybe 5 minutes and then come back, reconvene like 11:25?
Okay, 11:25 is okay. Okay, see you later sharply. Okay,
Okay.
thanks.
Perfect. Thank you very much.
Right. I think apparently we're starting early. So what I wanted to do is say something about judicial review of EU restricted measures. This is an area I think that's probably been in the news most among lawyers anyway, because of course the EU does allow persons, by which I mean both individuals and entities, to challenge their designation as subject to restrictive measures. That is usually to travel bans and asset freezes before the EU judiciary. And I just wanted to spend some time looking at that. I have to say this isn't a new development, but it is a development where matters have been, I think it's fairly safe to say, driven very much by the Court of Justice. And as a result, I will go over some of the things that I said previously. Now, one of the things I just wanted to look at beforehand, to begin with, is to sort of think about what we mean when we're talking about restrictive measures, because there's I think a certain lack of clarity sometimes about what they are and what they're about. This is what the European Commission said just about a year ago about restrictive measures, and it said, in spite of their colloquial name sanctions, remember I said the term sanctions or economic sanctions is not a term of art. EU restrictive measures are not punitive. They're intended to bring about a change in policy or activity by targeting entities and individuals in non-EU countries responsible for such malignant behavior. Now that's an interesting that's an interesting statement because it contrasts restrictive measures, which it says are forward-looking. They're about ensuring compliance, changing behavior, with penal sanctions, which are often seen as backward-looking. I don't think, frankly, that's entirely true with penal sanctions, but it tends to be penal sanctions are punitive. They punish you for something you've done. Restrictive measures, it says, are about encouraging changes in behavior. Now, I'm not sure that's entirely correct, and there was a very interesting statement made not by an EU judge, but by a judge in Courts of England and Wales only last month in a case called Shivdler and Secretary of State for Foreign Commonwealth and Development Affairs, which was a challenge to UK sanctions before the Courts of England and Wales. And in that case, the judge, Mr. Garnham, said any sanctions regime is likely to be backward-looking, focuses on past actions not yet then unlawful. That, I think, is not entirely true. It's perfectly possible for someone to be sanctioned for actions that were unlawful at the time. But here we're looking at a context where someone was sanctioned because they were seen as associated with or receiving a benefit from the government of Russia, which is something that wasn't seen as unlawful at the time. It says the 2019 regulations, they're the relevant UK regulations, and to a large extent they simply reflected, given their date, EU restrictive measures in force at the time. We're talking about the UK on leaving the European Union. The 2019 measures refer expressly to past conduct as providing the ground for designation, To be effective, sanctions need to send messages to the designated person and others in a similar position that the conduct in question is unacceptable. You might say, well, it's not very useful signaling now something that they've done previously. And then it says the value of such messages persists even if the person in question ceases the conduct complained of and makes statements distancing himself from the Russian regime. Now, the cynical among us could say that's a fairly frank admission that sanctions are, if not punitive, or possibly not only punitive, but in fact implorative. They're meant to be, that they are meant to be, but whatever you think, they are meant to be coercive. Even if they're not punitive, they are meant to be coercive, and they have quite considerable impacts on the individuals who might be sanctioned. So if you look at Mr. Schindler, in that case, well, there are lots of sad things that he tells the court about how he can't run his yacht and how he can't get the staff for his house. But more to the point, perhaps, how his 2 children had to be withdrawn from school because the school, in each case, excluded them. You know, so that they're not sanctioned, but they have obviously had their lives considerably disrupted. And consequently, because of that, individual rights are engaged. And as we know, that's something that has to be taken into account. Just to remind you, Article 21 of the Treaty on European Union talks about the Union's actions on the international scene shall be guided by respect for the principles. It talks about the rule of law, the universality and indivisibility of human rights, fundamental freedoms, respect for human rights, and international law. So the EU does see itself as an organization that respects human rights and has a commitment to the rule of law. And this is very much what the Court of Justice said in Cardi. I've already mentioned Cardi, but it's the important case here. Mr. Cardi is sanctioned, he's subject to EU restrictive measures, with the EU implementing a decision of the United Nations Security Council. The argument is made that the United Nations states' obligations under the UN Charter trump any other obligations they might have under international law, i.e. their human rights obligations in particular. The Court of Justice says no, all community acts, even community acts which are implementing Security Council decisions, must respect fundamental rights, which constitutes a condition of their lawfulness, which it is for the court to review. And it talks about the framework of the complete system of legal remedies established by the treaty. So when the council designates a person as subject to restrictive measures, that must be compatible, that decision must respect that person's fundamental rights, and they have one of the things that that person has is a right to challenge the lawfulness of their designation before the Court of Justice of the European Union. I'll skip that. That's simply the second slide simply goes into more detail about the relationship between the UN Charter, between international law and EU law in this case. I simply recall that originally, when the matter went to the then Court of First Instance, the General Court, it said it could only review it with regards to the compatibility of essentially the Security Council resolution with jus cogens rules in international law, although I think that the Court of First Instance made rather a mess of what jus cogens was, particularly as it seemed to think that the right to property under international law was was a norm of jus cogens, which I think simply can't be right for reasons I'll come into. So what do you do? What do you do? Well, if you remember, it's Article 163 of the Treaty Functioning of the European Union. You can go to the Court of Justice of the European Union to challenge acts of, here, the Council. Any natural or legal person may institute proceedings against an act addressed to that person or which is of direct or individual concern to them. Now, my view is that if you are designated as subject to restrictive measures, the act is addressed to you, but it's even if you don't accept that, it's certainly of direct and individual concern to you, and that's been accepted for a long time by the court. Of course, we know that targeted sanctions are, of course, Janus face. They address two sets of people. In many respects, I think they don't actually address the individual, because it doesn't, until recently, when we got circumvention and so on, a person subject to restrictive measures wasn't really under any obligations. It was just that everyone else was obliged to freeze their assets and not to allow them access to economic resources. But in any case, they do have a right to challenge, and you have 2 months from the publication of the measure or its notification to the plaintiff, plus the 10 days on account of distance given to you in the court's rules of procedure. There have been arguments. It's generally notification. So what the council will do if you are subject to restrictive measures is if they know your address, they'll write to you and they'll tell you that you are subject to restrictive measures and you can make representations. They don't tell you generally in advance for fairly obvious reasons. And if they don't have your address, obviously the decision is published, and I'm sure that if you're, I don't know, a Congolese warlord or someone like that who's been sanctioned, the official journal is your regular reading, and you will soon have it drawn to your attention. In fact, I've got a very distinct suspicion that there are a number of lawyers who assiduously read the official journal to see who's been subject to restrictive measures, and then using the information contained therein, write to those people to offer their services to challenge those designations. Oh, that may be unduly cynical on my part. So anyway, it's an act of the council, and it can be challenged before the Court of Justice of the European Union, providing you bring your challenge. If you're subject to designate, providing you bring it within the rather brief time limit. I should say what you're basically, annulment is the remedy. The court in many cases simply prospectively annuls the act, which means they say, well, it won't apply for, I think it's generally 3 months, isn't it? Thereafter, it will cease to apply in 3 months' time to give the council time to designate you on another on other grounds or on the basis of better evidence or something like that. It's theoretically possible to claim damages. I think damages have been awarded precisely once in these cases, so it's very theoretical. Real question is, I think, on what basis? Now, there are, I think, 2 issues about the legality of sanction, and I'm going to look at this in terms of human rights, fundamental rights. The first is their compatibility with substantive human rights. The second is compatibility with procedural human rights. Now, if you look, almost all challenges claim that the individual's right to property, right to carry out a business, right to private and family life have been breached. Now, the important thing to remember with all of those are they are not absolute rights. They are qualified rights. The only absolute right here, I think, that could possibly be engaged would be the right not to be subject to degrading treatment. If designation reduced due to penury, that you became, because you couldn't access any of your assets, you weren't able to support yourself. Now, that's quite unlikely in many cases because the sanctioned persons aren't located, aren't resident within the European Union. But of course, in terrorist-related sanctions, that has been the case. But it's not a problem. Why is it not a problem? Because there is provided for a system of exceptions of licenses. So if you need money for ordinary expenses, or indeed for exceptional expenses, provision is made. And that traditionally has been dealt with by the national authorities, although we are seeing the Commission in particular taking more of an interest in that. There's very little jurisprudence thus far from the Court of Justice on that, because those battles, I think, go on at the national level. The only case I can, and Francesca will correct me if I'm wrong here, the only case I can think of is a case which came not by way of Article 263, but by way of the preliminary reference procedure, where it was, I think it was a complaint made that the Lithuanian authorities were refusing to allow a designated individual access to their assets to pay lawyers to challenge. And the court basically said that would be unlawful. You've got to, if someone wants to challenge, you've got to allow them access to their assets to pay their lawyers. But I can't remember what that case is called. Francesca got it there. It's case C 314/13. I'm really not going to try and pronounce the name. I'm afraid my Lithuanian leaves, it is Lithuanian, isn't it? Leaves much to be deserved. So we're not concerned with degrading treatment. And what I'm going to concentrate on really is the right to family life would seem to be engaged, particularly by travel bans. What I really want to engage in, I think, is the right to property, which of course is a fundamental right under the Charter of Fundamental Rights in Article 4, and of course in the European Convention of Human Rights, Article 1 of Protocol number 1, both says that persons have a right to property. And as a brief aside, I would say that that's not just natural persons, it's also legal persons. Rather oddly, you might think, but we talk in the EU of fundamental rights rather than human rights. And I mention that because there is no right to property under the International Covenant on Civil and Political Rights, which I think is one reason for being suspicious of the then called first instance conclusion in Cardi 1, that the right to property had jus cogent status. But generally, the EU courts, and I think rightly the EU judiciary has said that that asset freezes are not unlawful. Why not? Because one, they're not an absolute deprivation of property, because they are freezes. We're not talking, we'll come back, I think Anton is going to talk about this later. We'll come back to questions of moving from freezing to seizing of assets, but the courts so far have said that there is not a transfer of property here. What there is a restriction on the use to which property can be put, and that's important. And secondly, the court said that asset freezes are acceptable because they're proportionate, therefore there's a legitimate aim there, and it is not necessary, but they're willing to give the the council leeway there. So to go back to a fairly early case, Bank Melli and Council, which as you can see, it's an Iranian bank challenging its designation under the Iran sanctions, which were not in this instance Security Council sanctions, so they're autonomous unilateral sanctions. The court said the applicant's freedom to carry on economic activity and its right to property are restricted to a considerable degree on account of the adoption of the contested decision, for it may not in particular dispose of its funds situated within the territory of the community or held by community nationals, except by virtue of special authorization, i.e. Except through the obtaining of a license. However, two things. Given the primary importance of maintaining international peace and security, the disadvantages caused are not inordinate in relation to the end sought. So there's your proportionality analysis. You've got a really important aim here, maintaining international peace and security, specifically with regards to Iran, preventing nuclear proliferation. You could hardly think of something that might not, of a more important or cogent aim. And it said, so, and then, you look at the advantages, you weigh the advantages against the end sought, you weigh the disadvantage against the end sought. And here, the court says, especially because one, those restrictions concern only part of the applicant's assets. As I said, the applicant here was an Iranian bank. It held bank accounts, I imagine, in a number of EU jurisdictions, but it also had probably the majority of its assets were held in Iran. So it's only a part of its assets that have been frozen, that are subject to this restriction. And secondly, again, there are the particular regulation provides for certain exceptions, allowing the entities affected by fund freezing measures to meet essential expenditure. So a proportionality analysis, this is not, it's a restriction, it's not a deprivation of property. And when you engage in a proportionality analysis, the weight is very much placed on the importance of the aim. Now, I think there's one problem here, which I'll come back to, which is, I think the distinction here between restrictions on the right to property and a deprivation of property is in many cases more formal than real, because as we know, sanctions regimes, restrictive measures regimes can last for years, if not decades. Particularly if you're an individual, if the asset freeze lasts, as it could, 10, 20 plus years. Think how long US sanctions against Cuba, for example, have persisted. We're talking well over 50 years now. Then the idea that you might get them back at some unspecified future time is perhaps not enormous consolation. Also, in some cases, I saw this in a case in the English courts concerning enforcement of an arbitral award against us, rendered in favor of a sanctioned Iranian entity. Restrictions on getting hold of your asset may mean that the value of the asset in real terms considerably is considerably lessened, considerably reduced. So I think you have to be careful, that may be more formal than real, but nonetheless, I think the court would say, really what we're doing here, there is always the possibility that matters will change, that you'll get your assets back, or rather you'll be able to enjoy your assets again. And in any case, even though it's accepted, the restrictions are quite considerable, the ends sought by the sanctions, by the restrictive measures, are very important. So you've just got to lump it, I think, is probably the reason, the answer. And you can see that in many cases, I think that makes sense. I was at a conference only a couple of weeks ago, and someone said, well, if you're a Russian oligarch, your assets within the EU, within the UK, etc., are frozen. Well, what does it mean to you? Well, it means you can't go on holiday in London. You know, you can't go shopping in Harrods. You can't go on holiday to the Côte d'Azur. But, you know, is that really that bad? You know, you can still, you know, shop in the designer shops in Moscow. You can still go to the seaside in Sochi on the Black Sea. It may be rather different, however, if you are within the EU and consequently all your assets are frozen. So different cases, I think, maybe the analysis might be different, but we find that in fact it isn't. So the general view, and I say this with regards to the right to property, with regard to the right to private and family life, with regard to the right to carry out a business, has been that these are qualified rights. Undertaking a proportionality analysis, the restrictions imposed are not inordinate in relation to the ends sought. The ends sought are usually pretty weighty: preservation or restoration of international peace and security, you know, acting against, seeking to prevent nuclear proliferation, seeking to ensure respect for human rights, humanitarian law, resisting aggression or attacks on people's right to self-determination. You know, fairly fundamental pillars of the current international legal order, one might say. What about procedural rights? I think that's the more interesting one, and this is really where CARDI is perhaps important. Now, if we look at the EU Charter on Fundamental Rights, Article 4, I'm just going to refer to Articles 41 and 47 here. Article 41 says we've got a right to good administration. That includes a right to be heard before any individual measure which would affect you adversely is taken. As I've said, there can be exceptions to that, and restrictive measures are often that, because, you know, if someone tells you all your assets in the EU are going, we're thinking of freezing all your, someone said to you, we're thinking, and you're a Russian oligarch, we're thinking of freezing all your assets in the European Union next week. Well, maybe you might move them beforehand. But you also have the right to have access to your file to an extent, while respecting the legitimate interests of confidentiality. And there's also an obligation on the administration to give reasons. So when it's accepted that when the council designates persons as subject to restrictive measures, they've got to provide reasons, and indeed they've got to give access to the file. They've got to provide reasons, and indeed they've got to provide the evidence on which is the basis for designation. Now, back in it's probably now over 10 years ago now, isn't it? There was a period when the council would simply go, these are the reasons. You can't have access to the dossier. Well, you can have access to the dossier, the file, but it's not there because the information on which we made this designation is confidential, it's secret, it's what's called closed source material. It's intelligence information, for example. But we're not going to tell you about it. If we did, we'd have to kill you, something like that. And the court, in a number of cases, just said to the council, well, if you're not going to provide any evidence, we're going to assume you don't have any, and therefore this designation will be annulled. Now, two things happen. I don't think the council was particular. Two things happen. Firstly, the General Court, first of all, changed its procedural rules to allow it to deal with closed source material in the without applicants and their lawyers having access to that material. Now, I think there are real problems with that on the rule of law basis. It is something that is now accepted in a number of national legal systems, but I think it's still problematic. And I think it was particularly problematic the way the court took from those legal systems. And I'm not going to deal with that because the council changed its practice. What the council changed its practice to do was to rely on open source material. So what usually happens now is that designated person gets the reasons, and then when they get the file, they get the evidence, and the evidence is things like newspaper reports, things like that. It's stuff that's all out there, and there's plenty of stuff out there. And on the basis of that, the reasons, that's the basis for the reasons for designation, and so on and so forth. So there's been a move from closed source reliance, at least formally. I don't know what goes on in the council. Our reliance moved from closed source to open source material, but nonetheless, it does mean that if you are a person who is subject to restrictive measures, you have a right to know the reasons, you'll be told the reasons, and you have a right of access to the file and to the evidence upon which your designation has been based. It's the first thing you have. Second thing you have is you have a right to effective remedy, fair and public hearing within a reasonable time by an effective, independent and impartial tribunal established by law, with the possibility of being advised, defended and represented. In other words, you have a right to go, and we know this because we've seen it already, Article 163, Treaty Function of the European Union. You have a right to challenge your designation before the EU judiciary. You can do that. So what do? You write to the council's meant to tell you you've been designated. It's meant to allow you to make representations. Never pay any attention. Well, never say never. It's unfair. Normally it doesn't make much difference, but then a designated person can have a right to access to their dossier, although often it's quite heavily redacted when you get it. So, for example, you normally don't know what state has proposed your designation. But then you can, and the other thing is it may take some time for the council to give you the file as well. Whereas the clock is ticking, got two months plus 10 days on account of distance to bring your challenge. But you can make your challenge to the general court. And if you lose there, or if you win there, council appeals before the Court of Justice. And as I said, you're entitled to be represented, and if you should be able to access your assets in order to pay your lawyers, which is quite important because by and large lawyers like to be paid. So you've got right to effective remedy, right to a fair trial, and quite a number of persons have sought to challenge their designation with greater or lesser success. Now, you could ask for provisional measures. You could ask for the lifting of your designation while the proceedings go on. It's very rarely granted. I think the only person I can think of, Francesca, it's that pay to drive driver. What's his name? The Formula One guy. Mazepin. He got his lifted, didn't he, to allow him? Yeah, he's the only one we can think of. By and large, you just have to stick it out Hopefully the court will deal with you within 18 months. I suppose that might be a bit optimistic. 18 months, 2 years. So there you are. But you do have access to the EU judiciary. Francesca, has there been what are the statistics on successful challenges?
In the past, successful were like 2/3.
Yeah, but it's gone down, hasn't it?
Yeah. Very down.
Yeah, it's gone very much down. Largely, I think, to put it bluntly, the council was quite bad at defending these cases at the beginning. As I said, its reliance on closed source material didn't help it. And so it lost all those cases to begin with. But it's got, you know, and it's unsurprising the council's got a much smaller legal team than the commission, and they're a bit less used to being sued by individuals before the Court of Justice, but they've definitely upped their game in the past decade or so, and I think now it's the exception to win now, I would say, rather. But there we are. So, but there is a right of access to the court. The question is, you know, and this is what the court said in Cardi. It said the effectiveness of judicial review guaranteed by Article 47 of the Charter of Fundamental Rights requires that as part of the review of the lawfulness of the grounds, which are the basis of the decision to list or to maintain the listing of a given person, courts of the European Union are to ensure that that decision, which affects that person individually, is taken on a sufficiently solid factual basis. So that's the test. Now, quite what that means, I don't think anyone's entirely sure. But it goes on to say that entails a verification of the factual allegations in the summary of reasons underpinning that decision, with the consequence that judicial review cannot be restricted to an assessment of the cogency in the abstract of the reasons relied on, but must concern whether those reasons, or at the very least one of those reasons, deemed sufficient in itself to support that decision is substantiated. I mention this because what often you have is that the council provides a list of reasons, the basis of which a person is designated in order to be have the decision annulled. The person's got to knock out all of them. And knock out all but one and can still remain designated. So you have to show that at least one of the reasons is substantiated, i.e. that it has a sufficiently solid factual basis. That's with regard, in particular, with the evidence which is presented by the council to the court to substantiate the reasons for designation. Now, I think the general criticism is that no one really knows what a sufficiently solid factual, but what is the standard here? So I'm just going to quite briefly go through the questions concerning the effectiveness of judicial review. The first is, well, the burden of proof seems to be, you know, and standard of proof. Well, it seems that the council has to show that there's a sufficiently solid factual basis, but it's not quite sure what that means. Interestingly enough, when the UK left the European Union, it had to enact its own sanctions legislation, which was really meant to move, it's been changed since, but move seamlessly from the EU restrictive measures to their own. And in that they included, because I think it was really concluded a sufficiently solid factual basis, no one really knew what it meant. They said that the standard is reasonable grounds to suspect. Now, reasonable grounds to suspect is frankly a pretty low standard, and I would suggest that the EU standard is not high, is no higher than that at the best. I don't know whether Francesca agrees with me, but that's my view. It's a pretty low standard, and it's certainly nowhere near the criminal standard. It's certainly not the decision maker is sure, or beyond it's, you know, beyond reason. reasonable doubt or non-fiction on team, anything like that. It's not that. It's not even the civil standard. You don't have to show, balance of probabilities, preponderance of the evidence. It's a pretty low standard, first of all. So it's difficult to challenge these cases. The second thing is there's another problem, which is the criteria for designation are often, particularly if you look in the underlying regulation decision, you'll find on what basis a person can be designated, and they're often pretty wide criteria. So obtaining a benefit from or supporting the government of Russia. What's that mean? We saw this interestingly enough in the early Iranian sanctions. It said something like, I think it was something like providing support, supporting the government of Iran, including financially. And the argument was made, well, everyone supports. Any civil servant is supporting the government of Iran. If you're a customs official on the Afghan border, you're supporting the government of Iran. Or if you're if you're not a civil servant, if you're a pistachio, this probably gross stereotyping, a pistachio merchant, you're supporting the government of Iran financially. Why? Because you're paying your taxes, and your your payments go to support the government of Iran. So the court actually said, well, it doesn't mean everyone. It doesn't mean normal taxpayers or or sort of minor civil servants, but it can pretty much mean anyone else, which included, insurance companies, banks, oil companies, companies providing logistical support to the Iranian National Oil Corporation, and universities engaged in research in cooperation with the Iranian government. That one I know all about, etc., etc. It's pretty wide ground, pretty wide criteria. So, and if you fall within that criteria, you're reliant then on the proportionality analysis. Really, that's where you end up. And you end up having to say, well, it might be right that I fall within the criteria. It might be right that there's a sufficiently solid factual basis to conclude that I fall within this very wide criterion for designation, but my human rights are violated. Why? Because my designation is disproportionate. And as I've said, proportionality review here tends to focus on the really important reasons for imposing the sanctions and the minor, I'm not going to say the minor inconveniences, as opposed to the inconveniences that sanctioned persons are subject to. So it's difficult. And finally, I just repeat this point. I don't think the proportionality analysis, to an extent, and indeed I think that it's not just the proportionality, but it's where it starts, particularly with the right to property, is that the view is taken at the beginning that we're not talking about deprivations of the right to property. We're talking about restrictions on the enjoyment of your property. And in many cases, I think that's a fiction. Now, so my conclusions, and I hope I've done this I think I've done it in 45 minutes actually, which is good. My conclusion is this. The EU it's not alone, but it provides a well-developed system for the judicial review of sanctions designation. You're certainly much better off if you're sanctioned by the EU than you are, say, by the US. And I would also say, having looked at the current decisions of the English courts, I'm not sure that the English courts are I think you're probably better off in the EU courts, to be honest. It's the first thing I'd say. The second thing I would say is, but in most cases, I don't think sanctions designations do violate substantive human rights. The right to property, the right to carry out a business, the right to private family life. Usually for the reasons given in Bank Melli, which is persons who are sanctioned are outside the EU. And what restrictive measures do is prevent you entering the EU and prevent you enjoying your assets within the EU. The rest of the world, only your home state, you can continue to do as you please. So if you are a member of the Russian government or a Russian oligarch, you can enjoy yourself in Russia, but just not in London. On the coast as you're in London, New York, wherever. However, it is important to recall that this is a fairly draconian regime. It does have potential, particularly for persons resident within the EU or who have very strong connection in the EU, to considerably affect those persons' lives. And as I said, the standard of proof is low, the criteria can be wide, and proportionality analyses can be skewed. I don't want to trespass on what Anton is going to say later in the day. I think all of this is worth bearing in mind when we consider whether, as various proposals have been made, the move is from freezing to seizing. And of course, final point, this is particularly relevant in terms when we look at the use of sanctions with regards to, kleptocracy or high-level corruption, or however we want to describe it. Traditionally, of course, we've gone after some things using well-established methods of mutual assistance in criminal matters and forfeiture and seizure, by which either the civil or the criminal standard of proof applies. Simply importing sanctions here, I think, is not unproblematic, but I think Anton will talk more about that. He's certainly written more on it. Anyway, I'll end there. But if anyone does have any questions, please feel free to ask.
You can raise your hand, and we will unmute your microphone for you to speak. Alternatively, if you're more comfortable, you can type your question into the chat and we'll address them. So we are opening the floor to your question, if you have the moment.
Of course, it may be that everyone wants their lunch.
Okay, I see a hand raised by Mr. Anastasio. Maybe we can unmute his mic.
I do not see the raised hand. I'm sorry. What is the name of the participant? Ah, there it is. Okay, perfect. The permissions granted.
Thanks. Thank you. Thank you very much for your presentation. You mentioned that, of course, there's a wide criteria by the Council that tries to understand if the fact there is a factual basis, there's actually a factual basis for including the subject, the entity, into the sanctioning list. And I've heard that, I've read some papers on that, but I've seen that the court usually refrain from a judgment on the criteria and motives that determined the inclusion of the subject. This is, of course, because sanctions are a foreign policy issue and are a very delicate matter. But my question would be then, does the existence of a causal link, or at least to what extent the judgment on the criteria of the inclusion are part of the judgment about how and if the human rights of the subject are violated? Meaning, does the right to an effective remedy include that the criteria for including a subject into the sanctioning list are solid enough, and the causal link between the action of the subject and the criteria and violation is solid enough, or this is a thing that pertains only to the judgment of the council and has nothing to do with the human rights of the subject? This could be a question.
No, I think you're right. By and large, the court refrains from adjudicating on the appropriateness of the criteria, which I think is problematic for the reasons I've given. They're very wide. But I'm going to hand this over to Francesca, because what's been interesting is the inclusion of family members in particular. And of course, Yevgeny Prigozhin's mum was challenged her sanctions. But I think you know more about that than me, so perhaps you could
just add something. But interesting question. So, as you said, actually the council enjoys a broad discretion, and the court has clarified several times that cannot judge on the designation criteria, because this is up to the political discretion. This is clearly foreign policy, so the court is not competent to rule. And this is precisely the game of the council. So if the council wants to, by tomorrow, decide to designate every blonde Russian as a new criteria, that is the discretion of the council.
I think the court might get involved there, but
yeah,
but there have been some. No, I'll let you finish. Sorry.
It's just that it's precisely the point. For instance, in family members, at the beginning, family members were not explicitly referred as a designation ground, autonomous ground for designation. Then in June, the council added family members. Why? Because there was the first case of Violeta Prigozhina, the mother of Yevgeny Prigozhin, and at that time, Violeta won the action for annulment. So there was a successful annulment, and the council played the political card and the broad discretion, adding a new designation criteria. And now, as I referred in the previous discussion, we had family members that tried to annul the designations, and the court dismissed the action precisely because now family members can be designated as such.
Yeah, so I mean, I think you're left there with proportionality analysis, and the court again is very differential with these. I mean, I think that's where it does come in, to be honest. You could say, well, we don't say that you can't. It would be open to the court, I think, to say we don't say that you can't decide who to designate, but what we do say is that when we look at an individual designation, we have to decide whether it's proportionate. But by and large, the emphasis is generally on how important the aim is, rather than the inconveniences that entails. You need to. What's interesting, I think, about now I've forgotten what the case is called, which is very typical of me. Frankly, the most recent case in the English courts is that he actually had Schindler. He had a pretty good case in many respects. I think on the facts, he's not a Russian national. He's a dual UK US national. He lived in the UK. His kids were in school in the UK. And nonetheless, he was designated. Now, he had a number of interesting arguments, one of which was, he said, the reasons for his designation were association with Roman Abramovich, which is one that slightly worries me, to be honest. You know, I'm a Chelsea fan, so you know, possibly I could be designated for, I mean, obviously sold the club now, but you know, so I'm probably all right, but you know, it's a broad one. And the fact that he was a non-executive director in Evraz, and that's because it's in the extractive industries, isn't it? It provides the benefit to the government of Russia. And he said, look, you know, this isn't fair. There are lots of non-executive directors of Evraz, including Sir Michael Peat, who I think had been private secretary to the then Prince of Wales, now King Charles. And they've not been designated, and this just isn't fair. Why is it me? The only people who've been designated are some people of Russian or Ukrainian origin. But nonetheless, the English court said no. And it was a very well argued case, very, very heavyweight counsel on both sides. So it will be appealed, I'm sure. But if you can't win in a case like that on, you know, proportionality, you know, then you're not going to win, full stop, I don't think. Very easily anyway. Any other questions? I think it's nearly 1:30 anyway.
Yeah. If there are no other questions, I will thank the speaker, the one who have intervened today, and all of you. So this morning we had the opportunity to delve into the topic of restrictive measure and the analysis of circumvention with Happold and Francesca Finelli. So right now we are heading into our lunch break. We will reconvene at 1:30, I will say. In the afternoon, we will have Celia, Challet, Anton, Moiseienko that will discuss the EU measure against kleptocracy and also an important topic of the transition from freezing to seizing assets. And so I hope you're finding the webinar so fun, interesting, and useful to improve your understanding about restrictive measure and how they work. So if there are no more questions, I will say that we will start again at 1:30. And so have a good lunch.
Thank you. See you later.
Hello everyone, good afternoon. So I think that we can resume our session. So we are ready for diving into our afternoon panels. So we begin with Celia from the University of Ghent. She'll explore the relationship between EU restrictive measure and the misappropriation of state funds. We'll dive into key questions such as, do these measures target kleptocracy, how, and we'll also touch upon country-specific designations, citing examples from Egypt, Tunisia, Ukraine, and discuss their judicial reviews. Then we'll have Anton Moiseienko from the Australian National University that will guide us through the critical transition from freezing assets to seizing them. We'll discuss the interplay between sanction and crimes and ponder on the necessity also of EU Magnitsky sanction. So both panels are quite promising. So we invite you to engage, participate, and let's make the most of our afternoon. So let's begin with Celia Challet. Over to you. I give you the floor. So thank you, Celia.
Thank you very much. Good afternoon, everyone, and thank you to the organizers for inviting me. I'll just share my slides. Let me know if you cannot see them. I think this should be okay now.
We can see them, yes.
Okay, perfect. Thank you very much. So as it has been said, I'll be giving a brief presentation on the, tackling restrictive kleptocracy, but especially misappropriations of state funds through EU restrictive measures, and in particular with, the lessons from the Council sanctions practice and the Court of Justice. So since I cannot see you because of the slides, feel free to interrupt me if anything's unclear or if I'm going too fast or anything. But so basically, the question of whether the EU can and perhaps should tackle kleptocracy in general and, corruption through its restrictive measures has always, has been there in the debate for quite a long time. because also, as frequently stressed over time, well, corruption undermines the main objectives of the EU's external action as laid down in Article 21, paragraph 2 TEU, and these objectives being to consolidate and support the rule of law, democracy, human rights, and international law in some of the countries that the EU targets. And of course, the fight against corruption and kleptocracy seems to participate to the pursuit of these objectives. However, as of now, and unlike countries like the US, Canada, or the UK, the EU does not seem to have a specific corruption-related sanctions regime that would take the form of, for instance, a thematic horizontal sanctions regime. This has gained renewed interest recently with the questions on whether we could include potentially corruption in the EU's global human rights sanctions regime, or whether, as the Commission also suggested in May of this year, whether the EU should perhaps adopt a specific corruption-related sanctions regime. So we don't have any specific regimes like that, but the EU does have experience and country-based restrictive measures that have been tackling restrictive measures linked to misappropriations of state funds. A recent example of that was what we did with Lebanon in 2021, where the EU took restrictive measures in view of the situation in Lebanon and referring to persons that undermine democracy and the rule of law, but through, in particular, serious financial misconduct concerning public funds. But more importantly, and before that, the Council had adopted restrictive measures linked to misappropriations of state funds in Egypt, Tunisia, and Ukraine. And the story of these restrictive measures and of their judicial review by the Court of Justice, has underlined the legal challenges, or at least the burden of proof that lays with the Council when it makes use of these sanctions against individuals. And perhaps all these elements would be worth bearing in mind when discussing potential new sanctions regimes linked to corruption. So in order to make things as clear as possible, I'll just give you a brief element of background on precisely these sets of restrictive measures. Then the main takeaways from the Court of Justice case law, and then we'll try to summarize a bit what this means from the perspective of the Council's sanctions practice and perhaps for potential future sanctions regimes linked to corruption. Now, with respect precisely to the three sets of restrictive measures that I've mentioned, as we said, the EU adopted three sets of restrictive measures linked to misappropriation of state funds with respect to three countries, namely with respect to Egypt and Tunisia in 2011, and with respect to Ukraine in 2014. So all these sets of restrictive measures were adopted after the change of regime in these countries, and the purpose was, well, to support them in their democratic transition, or at the very least, to further consolidate rule of law and the protection of fundamental rights in these countries. And so clearly for Ukraine, the Council explicitly stated that the aim was to, support and consolidate the rule of law and fundamental rights in Ukraine. And for Egypt and Tunisia, the objectives were framed more broadly in terms of facilitating the democratic transition, but also the development of their economy and society. And of course, the Council adopted travel bans, but especially asset freezes against members of these countries' former elites who were being subject to investigations and or prosecuted in these countries in connection with misappropriations of state funds. And this was the case, I've put them of, for instance, the former presidents of Ukraine, Egypt, and Tunisia, but also of former members of their family and of their government. And as I said, the restrictive measures were meant to assist the authorities of the third states concerned in recovering the misappropriated funds, should they be qualified as such at the end of the national judicial proceedings. The listing criterion that was used by the Council in its restrictive measures was pretty straightforward. The sanctions referred to, I quote, persons having been identified as responsible for the misappropriation of state funds and persons associated with them. And with respect to Ukraine, this was then further clarified to explain that, by identified, we also meant persons being subject to investigations and not only judicial prosecutions, which of course is important. No more than a few dozen individuals were listed in these different sets of restrictive measures taken together. I think for Ukraine, we had a maximum of 22 members, 22 individuals. So it was not important for sanctions regimes quantitatively, but of course the symbolic and political and corruption-related dimension was of course very important. Now, beyond the objectives that were pursued by these restrictive measures, these three sets of sanctions shared several specificities, which, as we will see, quickly became important in the framework of the judicial review of the restrictive measures. First of all, it was not specified by the Council, at least in the legal instruments that provided for the restrictive measures, what was understood by, for instance, misappropriations of state funds, by being identified as responsible for such misappropriations, what the Council understood by investigations, judicial proceedings, etc. So there was no definition in the legal instruments of the key concepts to implement these sanctions. Secondly, because the Council was listing individuals and entities on the ground that they were subject to investigation and judicial proceedings in the third countries concerned, well, the Council had to prove that investigations or judicial proceedings were indeed ongoing in these countries. And so for that, it could, of course, only base itself evidently on the evidence and information provided by the authorities of these third states. So the Council fully relied on information and evidence of misappropriations of state funds transmitted by these states' administrative, but mostly judicial authorities, and of proof that, the procedures were ongoing. But of course, this state of play, which also led some authors to speak of a very atypical form of restrictive measures, were bound to at least quickly raised legal interrogations as to the reliability of this evidence. This is especially so since, a lot of restrictive measures, a lot of the proposals to list individuals came from the authorities of the states concerned. For example, in the case of Ukraine, you had the Prosecutor General of Ukraine that sometimes requested to the Council through Ukraine or through delegations to add individuals on the list because they were prosecuting them at national level. And sometimes when it maintains the people on the list, the Council, still used evidence and documents that were proving that procedures were still ongoing. So of course, you had a scenario where some third states were asking the EU to sanction their own citizens, and they were, in other words, acting as both judges and parties. And perhaps in connection to that, these three sets of restrictive measures quickly raised the question of these third states' compliance in the judicial proceedings with due process and the rights of the defense. It was not clear at the time, and it's perhaps still not clear now, that the third states concerned ensured the same standards of due process, rights of the defense, right to a fair trial, as we potentially expect within the EU. And this was all the more so that, as I've said before, these restrictive measures were precisely adopted in a context where democratization had not been necessarily completed, or at least that the states were still in need to implement reforms in terms of rule of law and perhaps also of judicial independence. So, of course, the Court of Justice was quickly brought to tackle questions that surrounded the legality of these restrictive measures linked to misappropriations of state funds, but also with respect to the burden of proof that the Council had to comply with when it added and maintained people on the list. So now moving on to what the court said, because of course, what is very interesting about these specific sets of restrictive measures is that they have led to a very particularly high number of actions for annulment before the Court of Justice. And it's even disproportionate when you take Ukraine, because at least 58 cases have been adjudicated on the merits regarding Ukraine, 19 regarding Tunisia, and 17 regarding Egypt. So this is a very massive caseload, especially if you think that, as I've said before, we didn't have so many individuals added on the list. So it clearly means that several individuals kept challenging the sanctions imposed on them over time. And so knowing that rather low number, the fact that they were members of the former elite and that potentially they had misappropriated funds, it is clear that they were going to have a certain tenacity, a certain procedural obstination to challenge the measures, and that they had the available funds, that they had the money to do so. At least we can expect that. So, of course, perhaps this is worth keeping in mind that if in the future the EU was to adopt new corruption sanctions regime, there might be a probability that there would be massive litigation, or at least important litigation, against these sanctions. The claim raised by the individuals against their listings were rather traditional in the sense of the judicial review of restrictive measures. So some applicants argued that, the Council had not motivated enough their listing, that there was no sufficiently solid factual basis, that there was a manifest error of assessment, or more broadly, that their fundamental rights had not been complied with. But of course, the specificities of these restrictive measures, which I mentioned earlier, quickly became an important part of these arguments and of the way in which the court replied to them. And in this respect, I think there are four main takeaways from the Court of Justice case law on these sanctions, which are important to bear in mind to a varying degree, but still relevant to mention. And these four takeaways are the following. So I think it's important first to recall that the court confirmed as a matter of principle that the council has the possibility to adopt restrictive measures for misappropriation of state funds, especially to consolidate the rule of law and fundamental freedom. So the council can do that. However, this does not mean that any person can be included in the sanctions for misappropriations of state funds. And this is where the court gave its own interpretation of the listing criteria and the scope of the persons who could be targeted by the council. Thirdly, the court, and perhaps more importantly, the court exercised a rather intense judicial scrutiny on precisely the burden of proof that the council had to provide to support the listings. So first of all, the court controlled whether there was a sufficiently solid factual basis. We'll come back to that. But more importantly, and if there's one takeaway from the case law that I think you should remember, it's this one. The court tremendously developed and increased obligations of verification on the council's side that the decisions of the third state authorities on which it relied to impose the sanctions were sufficiently compliant with fundamental rights and in particular due process. This is a fundamental takeaway of that case law, and it has completely altered the sustainability of the restrictive measures linked to misappropriations of state funds. But we'll come back to that later. Now, with respect to the competence to adopt such sanctions, it's interesting to see that the case law has confirmed as a matter of principle that the council may impose restrictive measures in support of the rule of law and in support of the recovery of alleged misappropriated state funds. It rejected, first of all, claims that there was no legal basis for the council to do that. So, for instance, some applicants argued that the council could not rely on Article 29 TU and the Common Foreign Security Policy because the only goal of the asset freezes was precisely to help the state authorities recover the money. And according to the applicants, this task laid with the national judicial authorities and not with the council under the Common Foreign Security Policy. But of course, the court rejected that outright and said that given that provision, Article 29, refers to, I quote, decisions that define the approach of the Union to a particular matter of a geographical or thematic nature, it is clear that, such restrictive measures fell into the scope of the treaties. It was also interestingly argued by some applicants that they could not be targeted by the council because they were former members of the government, so they didn't have any more links with the government of the countries concerned. And here again, the court said that, the council may target individuals regardless of any status or link with the state's current government, as long as this is provided so in the restrictive measures. And interestingly, and also I think very relevant to keep in mind, especially in the current context, the court rejected claims that related, in essence, to the political and rule of law situation in the countries concerned. So, for instance, the court rejected the argument that was made by some Tunisian applicants that, well, because Tunisia had allegedly completed its democratic transition, well, the measures were no longer needed. And the court said that regardless of the stage of democratization of a country, it is still necessary to have these measures to further support the consolidation of the rule of law. And the court also rejected the opposite arguments made, for instance, with respect to Egypt or Ukraine, that, the restrictive measures were no longer lawful because of the rule of law deficiencies in these countries. So a lot of applicants argued that, due to the former and current political and institutional situation in Egypt and Ukraine, well, there were infringements of fundamental rights, the rule of law, and that as a result of that, they were not being offered a fair, impartial, and independent judicial treatment in the procedures against them. And as a result, according to these individuals, the council, by failing, in fine, to ensure that the legal proceedings in these countries respected their fundamental rights, while the council had infringed Article 6 to EU, Articles 2 and 3 to EU, and various provisions of the Charter of Fundamental Rights. And here again, the court rejected that. It considered, at least at the beginning, that there was no evidence that the developments in Egypt and Ukraine affected the capacity of the judicial system to protect both the rule of law and fundamental rights in general, and within the proceedings against the applicants in particular. And the court said, at least at the beginning, that even in a scenario where the EU would express concerns over the fundamental rights and rule of law situation in a specific country, which it did actually regarding Egypt, assisting these countries in combating misappropriation of state funds was not at odds with the principles of the rule of law, but on the contrary, complementary to these objectives. And finally, in the case of Ukraine, the court insisted at the beginning on the fact that Ukraine was a member of the Council of Europe, that the new regime had been recognized as legitimate by the EU and the international community, and that more globally, it was not for the court to question the lawfulness of the new regime or the Council's political choice to support it. So overall, a broad margin of appreciation left to the Council with respect to tackling, if not corruption as a whole, misappropriations of state funds in general. That being said, the court also clarified very quickly what was to be understood by the listing criteria. So what was the material scope of the restrictive measures? Because, as I said, there were no legal definitions in the legal instruments, and of course, applicants quickly raised arguments challenging the understanding of the provisions. But overall, as we will see, the court kept a rather broad interpretation of what the Council can do. And especially the court provided elements of definition on three main elements of the listing criteria. First of all, the court explained a bit what was to be understood as identified as responsible for misappropriations of state funds. Because, of course, some applicants were wondering whether identified meant being responsible for, being convicted for, being found guilty of misappropriations, especially since there were a few linguistic divergences in the legal instruments, depending on the language. So the court clarified that clearly it is not required for a person to have already been convicted in court in order to be listed under the listing criterion of identified as, because otherwise, of course, the effectiveness of the asset freezes would disappear. And then, especially in its case law regarding Egypt, the court clarified that 5 potential categories of targets can fall under the notion of identified as. First of all, well, the persons that have, at the end of judicial proceedings, been convicted for the misappropriations of state funds. The associates, secondly, of these persons, so basically those who have been found to be their accomplices by a criminal court. Thirdly, persons that are currently being prosecuted for misappropriations of state funds. Fourth, those who are being prosecuted for being their associates, their accomplices. And finally, the court was not necessarily clear, but it said basically all those persons who are the subject of proceedings which that are connected to criminal proceedings for misappropriations of state funds, who may on that basis be described as associated with prosecuted individuals. So basically people connected, prosecuted in connected, I assume, investigations and procedures. And interestingly, the court also said that, this includes persons who, I quote, possibly without their knowledge, may have benefited from the proceeds of the misappropriated state funds, and on that basis are subject to protective measures prescribed in a judicial context intended to preserve the assets arising from the misappropriation. So clearly this, I assume, tackled the hypothesis of, the family members of those who did misappropriate the state funds. Second important element that the court defined was the notion of misappropriation of state funds for the purpose of the sanctions. And here the court clarified very early on that this was to be understood as an autonomous concept of EU law, which overall meant, and I quote, the illegal use of funds of assets belonging to or under the control of a public figure for a purpose contrary to that for which those funds of assets were intended, particularly for private purposes. So that would exclude criminal activities linked to the unlawful handling of private funds. And the Court of Justice clarified later, at least regarding Tunisia, that this illegal use must have harmed the financial interests of the state or the public community at stake, and that it must have caused damage that can be assessed quantitatively in financial terms. However, that being said, the court accepted that while being autonomous, the concept of misappropriation of state funds can vary in scope depending on the EU restrictive measures at stake, the national law applicable, and the facts of the case. For instance, typically regarding Tunisia, the court said that the concept of restrictive measures could apply to actions that had not been characterized as such by the Tunisian judicial authorities in the context of a judicial investigation, but which could correspond to the Council's intended definition of that concept in its sanctions. So clearly you could see that the Council was allowed basically to potentially go further than what the national authorities were doing. And regarding Ukraine, the court also said that because, as I've mentioned, in the recitals of the legal instruments, the Council said that the objective of the restrictive measures was to consolidate and support the rule of law in Ukraine, well, this had an impact on the scope of the concept. The Court of Justice considered that, contrary, for instance, to the restrictive measures linked to Egypt or Tunisia, Well, the ones linked to Ukraine went beyond the mere objective of helping the national authorities with the recovery and really encompassed respect for the rule of law and fundamental freedoms. This means that not any act classifiable as misappropriation of state funds justified EU actions under the Ukrainian sanctions regime. The court said that, I quote, it was at the very least necessary that the disputed acts should be as such as to undermine the legal and institutional foundations of Ukraine. So there was a form of perhaps indirect threshold of below which the listing of individuals under the Ukrainian sanctions regime was not justified. So you can see the importance from the Council's perspective of defining the objectives of the restrictive measures, perhaps the key concepts, because this will shape its own practice. And also, if you don't provide any definition, then this doesn't rule out that potentially the Court of Justice might give its own interpretation, own understanding of the scope of your sanctions. And finally, and I'll be quick on that, the Court of Justice clarified that, also still in the topic of misappropriation of state funds, that changes in the situation of the allegedly misappropriated funds, that does not necessarily mean that the sanctions should be removed. For example, the court said that it's not relevant that the funds of the applicant are no longer subject to restrictive measures in its own state. The court also said that even if the applicant has reimbursed the misappropriated funds to the country concerned, it doesn't mean that the sanctions should be lifted. Why? Because first of all, the court said, well, it is for the state's authorities to draw the consequences from such reimbursement. And secondly, and this is important according to the court, the council did not freeze the assets of an individual because he was allegedly the beneficiary of misappropriated funds. The council sanctioned that person because of his involvement, in that conduct. Sorry. Can you still hear me? Okay, sorry, I had an issue on my computer. And finally, and very quickly, the court clarified the notion of investigation and judicial proceedings for the purpose of restrictive measures. So the court did not lay down too many developments, but it did say that with respect to judicial proceedings, they are not necessarily limited to just the final judicial decision that found somebody guilty of misappropriation of state funds. It can encompass judicial acts before the final decision, but also potentially other judicial acts that would be necessary to implement that final decision. And regarding the notion of investigation, and this is interesting, the court said that, I quote, the mere fact that an applicant may not previously have been aware of such investigations and that he or she has not been questioned in that regard by the authorities is not sufficient to cast doubt on the existence of this investigation. So again, a rather broad margin of appreciation for the council. But still, the court showed that it was willing to define and interpret these key concepts, and that this can potentially impact the council's burden of proof. The third main takeaway of the Court of Justice case law on these restrictive measures relates to the factual basis. So, of course, you know, I think that a key obligation for the council when it lists people and entities under listing criteria is to show that they do fall within the listing criteria. And so, in other words, there has to be a sufficiently solid factual basis to justify the listings. And in this respect as well, the court has laid down development in its case law on restrictive measures linked to misappropriations of state funds, especially with respect to Ukraine, because the court annulled several listings based on the lack of sufficiently solid factual basis. You might wonder why there would be sufficiently a lack of such basis, because the procedures were pretty straightforward. But this is because, at least for the initial listings, the council only relied on, especially with respect to Ukraine, on the letter of a prosecutor general of Ukraine, which stated that, first of all, some law enforcement agencies of Ukraine had launched proceedings to investigate certain acts concerning certain senior officials with regard to whom the investigation had established misappropriations of state funds. And the letter also said, for instance, that investigation verified the involvement of other people, in these crimes, and that it was planned to notify them shortly of suspicion. And for the court, what was a problem is that there was no sufficient basis to prove that the applicants were indeed identified as responsible for misappropriation of state funds in the meaning of the listing criteria in the sanctions. This was because, although it was sent by a high judicial body in Ukraine, the letter contained only a very generic and general statement linking the applicant's name to certain investigations, but that there were no details as to the establishment of the acts under investigation and the applicant's individual conduct, liability, responsibility with respect to those acts. So, in other words, the council did not have any information regarding the specific conducts attributable to the applicants. And so, as a result, the council was not in a position to establish that, first of all, these acts could be characterized as misappropriations of state funds, and secondly, that they could undermine the rule of law in Ukraine, and therefore that the criteria were fulfilled. So, and the court made it clear that it did not question the reliability or the validity of the letter from the General Prosecutor of Ukraine. The court also did not rule out that the council could rely on this. And also the court did not make, a list of documents that would be necessary to justify the listing. But this letter as such was not sufficient. So we can also see then that, when adding people on the list for misappropriation of state funds in a third country, it is important that the council gets precise information from the national judicial authorities as soon as possible, and even in the event of an initial listing, which might not necessarily be easy because at the beginning of the procedure, the national judicial authorities might not have a lot of procedures going on, a lot of documents, etc. But it's still important that they provide enough information in order for the council to be able to prove that the listing criteria are fulfilled. And now moving on to the last and, in my view, most important takeaway of the case law on these restrictive measures is the one of the use of third states evidence. Because as I've mentioned earlier, a key issue with these sanctions was the fact that the council was relying, I think exclusively on evidence and information transmitted by these states' authorities to the EU. And here, clearly, the Court of Justice progressively but drastically increased the burden of proof on the council. There were three main steps on the case law. I'll go through them as quickly as possible, but just to show you a bit the evolution in the case law and all the obligations that the court added progressively for the council, to show you also how difficult it is now to fulfill that burden of proof. So initially, in its first judgments, the court stressed that the council had a wide margin of appreciation when acting upon the request of the third state's judiciary, that the idea was, only to assist the third state's authorities in recovering the misappropriated state funds. And so, as long as the council showed proof of ongoing investigations or procedures, well, no additional verifications were required. What the council had to prove at the time was, first of all, as we always say, that the applicant was subject to criminal proceedings or investigations in connection with embezzlement. And secondly, that he could be qualified based on that as identified as responsible for misappropriations. And the council had to investigate further only if it could not establish these two elements. But more broadly, and especially in the case of Ukraine, the court considered that it was the council's political choice, as I've said, to support the states concerned. Ukraine was a member of the Council of Europe, etc., etc. The regime was considered as legitimate. And so as a result, the court considered at the time, and I quote, that if the council's decision to cooperate with the new authorities were subject to the condition that Ukraine should, immediately after the change of regime, already have, equivalent standards of protection of fundamental rights, well, the council's discretion would be undermined. And the same rationale was applied to the case law on Egypt and Ukraine, where the court did not even reply to arguments based on rule of law deficiencies with respect to the burden of proof. So the bottom line at the time was that it was for the listed individuals, to prove that there was an issue with the evidence on the basis of which they had been added to the sanctions list, with no guarantee that the council will proceed to the verifications, which was not in principle required to do in the first place. But this doesn't mean that the Court of Justice did not start already to lay down a few elements of obligations on the part of the council. Because of course, we could see that the court was progressively becoming aware of some of the issues linked to the use of that evidence. Of course, 3 years after the beginning of the start of the judicial proceedings against Ukrainians, it was becoming, of course, increasingly difficult to overlook arguments by the applicants that, the procedures were not making any progress, that there were sometimes unexplained closure of proceedings, that there were intrinsic inconsistencies, according to some applicants, in the evidence used by the council. So the court maintained, the position that Ukraine was making improvements in the field of rule of law, etc., etc. But they still increasingly acknowledged that the arguments made by the applicants were such as to cast doubt on, the adequacy of the evidence used by the council, and that this should have led it to carry out additional verifications. And the court also acknowledged for the first time that the Council should have sought clarifications from the Ukrainian authorities as to the possible reasons for the lack of progress in the proceedings. So you can already see that, the court started stepping up the burden of proof required from the Council. But we had to wait for fundamental judgment in 2018 in Azarov versus Council to have a major shift in the case law of the Court of Justice. Because ruling on an appeal procedure, the court considered that there is an obligation for the Council to verify that the rights of the defense and the rights to effective judicial protection have been respected by the third state authorities at the time of the adoption of the decisions. So this is, of course, a fundamental change. And the court said that, the Council had to comply with a double obligation. On the one hand, ensure that the third state authorities have complied with the rights of the defense and the right to effective judicial protection at the time of the adoption of their decision. And secondly, the Council must refer in its decision imposing the sanctions to the reasons for which it considers that the third state's decision has been adopted in compliance with those rights. So you can see, of course, the massive difference that this made for the Council. And so the Azarov judgment also put an end to this form of somewhat presumption that Ukraine was complying with fundamental rights because it was a member of the Council of Europe. The court said, and I quote, that this cannot render superfluous the verification by the Council that, due process was being complied with. But while, that judgment was in fine aligning the standards of verifications that the Council had to verify on those that the court had already developed, for instance, for sanctions linked to terrorism, well, the post-Azarov case laws, the judgments that came after that, kept increasing the burden of proof on the part of the Council. For instance, and once again, the Ukrainian cases paved the way. So, for example, the court said that the Council has to ensure that the criminal proceedings on which it relies to maintain the sanctions do not conflict with the nebis idem principle with respect to the national decisions. The court also said that, where a person has been listed for several years on account of the same preliminary investigation conducted in Ukraine, the Council must explore in greater detail the question of a possible infringement of the fundamental rights of that person by the Ukrainian authorities. The courts also said that verifications must be carried out irrespective of any evidence from the applicants, and that, very importantly, from a legal but also symbolical perspective, the court said that this obligation of verification is a matter of public policy. So, of course, this was very stringent for the Council in legal terms, but also, I assume, perhaps in diplomatic terms, because, of course, you had the court basically telling the Council that it should perhaps trust a bit less the national authorities of the states concerned and ask them more information, with all the political sensitivity that this could, of course, create. And so, indeed, at that stage, the obligations imposed on the Council were already sufficiently stringent so as to make it particularly difficult to fulfill, the standards imposed by the case law, because, of course, there's a limit to what can be asked and obtained from third states authorities, and or perhaps more precisely to the possibility to prove that the judicial proceedings were complying with the defined standards established by the Court of Justice, when in reality, well, the evidence perhaps suggested that they did not. And this doesn't mean, however, that the Council did not try to adapt to the burden of proof imposed by the court. In fact, the Council has showed tremendous efforts to further justify, to further verify that the standards were complied with. If you look at the left of the slides, shortly after the Azarov judgment, the Council included in the sanctions linked to Ukraine for misappropriation of state funds a specific section, Section B, which was meant basically to explain how, in the Council's view, the applicable legislation was preserving the applicant's fundamental rights, and how in each specific judicial proceedings against each specific applicant, their fundamental rights had been preserved. So a lot of efforts put forward by the Council. And it's interesting to note that the Council also did that immediately for Egypt and Tunisia, even before the case law adapted the solution for Ukraine to Tunisia and Egypt. So you can see that the Council tried to anticipate, the developments of the case law. But this was still not sufficient to stop the annulment of the sanctions by the Court of Justice, which kept raising to no end the burden of proof. For instance, the court made it clear that it is not sufficient for the Council to mention the judicial decisions adopted in support of principal criminal proceedings. It has to justify that in the principal proceedings and the main proceedings, fundamental rights have been complied with. Also, each of the decisions relied on by the Council must leave no doubt as to their compliance with due process. So, for instance, said the court, a decision taken by an investigating judge without the applicant's lawyers and without any possibility of appeal cannot be relied on by the council. Neither can the decisions by investigating judges that have ceased to produce any effect. So you can see that this has become very constraining for the national authorities, but also for the council to maintain the listings. And the General Court even went as far as stressing that the council should have ascertained the extent to which the decisions relied on were consistent with the articles of the Code of Criminal Procedure mentioned in Section B of the Ukrainian Act. So you can see also how far the court went, and the court has basically been asking the council to verify whether the Ukrainian national authorities were complying with their own national criminal legislation. So of course, we can wonder whether the court did not go too far in the verifications that it's been asking from the council, especially with respect to, the domestic legislation of the countries concerned. But still, the problem is, or the impression is, that once the Court of Justice has started to have doubts on the rule of law and fundamental rights situation in the judicial proceedings at stake, and as long as the court felt that it was not convinced by the council that it had done sufficient verifications, well, it kept increasing the burden of proof. So now, very quickly, before I stop the presentation, to summarize all of this, what lessons can we then perhaps try to draw from the perspective of the council sanctions practice and other potential restrictive measures for corruption, especially with respect to the burden of proof? So, as you've seen, clearly, at least as far as restrictive measures for misappropriations of state funds are concerned, there is a lot of elements that the council is now supposed to prove. First of all, it needs to prove that the listing criteria have been fulfilled. So as we've said, that there are ongoing investigations or prosecutions in the state concerned in the meaning of the case law, that then this allows to draw the conclusion that we have persons identified as responsible for the misappropriation of state funds, as explained by the case law. And then, of course, due attention to the national context, as I've explained also with Ukraine and Tunisia, might come into play. Once it had done that, the council must also carry out all these obligations of verification, which basically means that it's supposed to ask and continuously verify, monitor the judicial proceedings in the states concerned, especially the main proceedings, but that it must check and ask that each decision comply with national criminal procedural law, that the debesidem principle has been complied with, that, when some procedures are basically being closed or reopened, or, that the authorities can explain why this has been taking place. And if the court or the council consider that there's a lack of progress in the proceedings, knowing that the court has not defined exactly after what time, after what deadline we consider that there's a lack of progress, well, even further verifications are needed. So, of course, this is a particularly high burden of proof, and the case law has showed that, the council could not sufficiently adapt to it. After the Azarov case law, the council has lost every single case, be it with regards to Egypt, Ukraine, or Tunisia, on the basis of these obligations of verifications. This ended up in the council lifting their sanctions regarding Egypt in 2021. Now on the Ukrainian sanctions list, we only have 2 individuals. Even Viktor Yanukovych was removed from the sanctions. And in addition, and perhaps as a form of warning to the council, we've also seen a recent judgment of February 2023 in Klimenko. I can give you the reference after that, where the court ruled on an action for damage issued by a Ukrainian applicant, which obtained, I think, for the 4th or 5th time, the annulment of the sanctions. And here, the court considered that the council had not sufficiently adapted to the obligations developed by the case law after a certain time, and that therefore it had violated EU law in a sufficiently serious way that it could potentially lead to the award of damages if the other conditions for damages were fulfilled. So you can see that now, if the council does not comply with these obligations, this can have much more significant consequences for the sustainability of the restrictive measures, for the effectiveness of the measures, but also potentially financially if the council was ever one day potentially sentenced to award damages. So what conclusions to draw, maybe very quickly, for other potential sets of restrictive measures linked to corruption? Well, if the EU was to move towards a standalone specific corruption sanctions regime, well, then perhaps, I assume, based on what we've seen, it would be important for the Council to explain what are the specific objectives of that corruption sanctions regime, how it understands corruption, because, of course, if no definitions are provided, we cannot exclude that the court might potentially interpret the notion of corruption, which could perhaps limit then the scope of the restrictive measures. Of course, depending on the evidence and information on which the Council would rely to establish corruption, the burden of proof would be different. If the Council were to rely, I don't know, on press articles, on public reports from international organizations or member states' intelligence, then perhaps this would be enough to justify the listings. But if the Council was relying on perhaps judicial proceedings in the states where the corrupted person was supposed to be based or prosecuted, then perhaps we cannot exclude that the court would be tempted to apply the obligations of verifications that it laid down for embezzlement to corruption, with of course all the difficulties that could perhaps create for the Council. Now, if the EU was to include corruption in its, for instance, EU global human rights sanctions regime, again, it might be necessary to define corruption for the same reasons, but also there might be a need for a threshold of gravity, which we didn't necessarily have for misappropriations of state funds, except for Ukraine. Because of course, under the global human rights sanctions regime, only serious, systematic, sufficiently serious human rights violations can be caught under that sanctions regime. So of course, the question of whether corruption could fit into these serious infringements of fundamental rights would need to be seen, or perhaps in that case, the sanctions regime would need to be amended. So this is all for my presentation. I know I've spoken a lot, but thank you very much for your attention, and happy to answer any questions.
Thank you, Celia, for your presentation. Now I think that we can open the floor to any question and before starting the Q&A session. I remind you that you can raise your hand or simply write your question on the chat. While waiting for a question, I can ask a question myself to Celia. So I would like to know then, so if there are therefore distinction in the obligation that a council must fulfill in demonstrating the ground of suspicion when dealing with, for instance, misappropriation of state fund compared to the case involving, for instance, the stabilization of territorial integrity. So do the obligation vary in relation to specific type of restrictive measure we are dealing with?
Thank you for your question. Just to clarify, you're asking me if the obligations of verification I've talked about also apply to other restrictive measures regimes?
Yeah, whether there are differences in relation, to the specific type of restrictive measure.
Okay, thank you for the question, which actually perhaps I should have answered to that in my presentation. But indeed, I mean, these restrictive measures are very specific within the sanctions of the EU. We've never seen that before. So I think that this level of obligations of verification is due to both the listing criteria. So because the listing criteria are being prosecuted, etc., but also because the court had doubts on whether we could rely on the specific third states information. I think the outcome of the case law was due to the objective of the sanctions, the listing criteria, the amount of proof that the council had, and the fact that the evidence was coming from third states. I think if it were member states that were providing that information, there would not have been these discussions. And now, compared to, for instance, the destabilization of Ukraine or, actions undermining Ukraine's territorial integrity, the Council does not have to verify that because the listing criteria are different. For instance, the Council said, okay, somebody is benefiting from Russian leaders or somebody is helping undermining Ukraine. So, of course, this doesn't require the same burden of proof, the same elements of information. And so the court will not ask these obligations of verification. So thankfully for the Council, if I may say, these obligations of verifications have been confined to the case of misappropriations of state funds. I don't know if that replies to your question.
Yes, indeed. Many thanks. I see a hand raised by Mr. Anastasio, so we can give this the floor.
Thank you very much. So thanks for your presentation. It was very interesting. I just wanted to ask you whether, sanctions for international order purposes or international policy purposes are, I think, sanctions related to corruption are, I think, another thing, meaning in one case, we are in front of policy needs. In the other case with corruption, we have an actual crime or what it is supposed to be a real crime, let's say. So the question would be, of course, mainly in the second scenario, the problem of jurisdiction would arise, meaning what's the jurisdiction of the United States for pursuing a corruption case that, you know, has had some influence for the United States for policy reasons, for political reasons, but that juridically speaking and legally speaking, let's say, has no grounds of jurisdiction to be tackled, to be pursued. So the question would be how and if there are problems of jurisdiction related to corruption-related sanctions, and if yes, if you see other ratios that could justify corruption-based sanctions, and if you know, or just there are an attempt to exert an influence, a political influence over other countries in other situations, as you know, USA, police of the world, which is the usual accusation that we have against the United States because of how they use sanctions. So this is pretty much the question. Thanks.
Thank you very much for your question. I think this question, which is also very interesting, touches upon many different aspects, which are all, you know, interconnected together for sanctions. I think, but then of course I speak under the control of potential other sanctions people who are with us today, but I don't think that the issue of jurisdiction is that strong in the case of corruption or violations of international law, in the sense that, you know, we've seen that with the US, but also with the EU. I mean, if you take the EU, the proceedings in Ukraine, Tunisia or Egypt had no jurisdictional link with the EU. So the only reason why we took corruption, I mean, misappropriation of state funds sanctions, was because we considered that this was, you know, in the light of our values, interests, because we also, I guess, wanted to push a political agenda to, you know, strengthen the ties with these countries, help them in democratic transition, etc. So I think the issue was not that much framed in terms of jurisdictions than in terms of values, interests, and policy objectives. Now, what justifies then the choice of, you know, going through restrictive measures in general, and within that, country-specific or thematic or corruption alone, then this can depend on various reasons. I would say that the first choice would be political. So of course, it's not the same to say we adopt a sanctions regime that targets corruption everywhere and anywhere. So we're not targeting we're not putting the finger at a specific state. We're just targeting its individuals if we consider that they are corrupt. This is different from saying we have issues of corruption in Egypt or Tunisia. We want to help them tackle that. The symbolic and rhetorical question is not the same. So, of course, the more you resort to thematic sanctions regime, the more you want to solve not that much issues of jurisdiction, at least I think, than, you know, all these problems. And then, of course, you might decide to tackle corruption in different sanctions regime, depending on the version of proof as it has been developed by the court or understood by the council. If you think that, I don't know, corruption is difficult to prove, then perhaps you will establish distinct criteria that might be vaguer, more easy to comply with, right? So if you decide to go for corruption in the human rights sanctions regime, it will be much more difficult to prove that corruption consists in a serious fundamental right infringement, etc., that would justify the sanction. So I think these are all the considerations. I don't know if that replies to your question, but happy to discuss otherwise.
That replies, I would say, yes, for now. Then I will maybe think about it and write in private if I'm still curious. Thanks a lot.
So if there are no further questions, I think that we can make our usual break of 10 minutes. And then, of course, thanks Celia for her contribution, and then start with the final panel of our training today that will be dealt by Anton Moiseienko. And so I think that we can start in 10 minutes. So have a small break and see you soon. Okay, I think that we can restart. So let's restart with the final panel of our session today. So for us, there will be Anton Moiseienko from the Australian National University, and he will guide us through the critical transition from freezing assets to seizing them. Now I will leave the floor to Anton. The floor is yours.
Very much, Giovanni. Good afternoon, everyone, and thank you for having me. It's a great pleasure to continue living on European time despite being in Australia and being able to join events such as this one. Unfortunately, I didn't get to see the entirety of Celia's presentation, but I caught the end of it, and I thought was really fantastic, and the quality of Q&A was really exceptional. And I think that that presentation really touched on some of the issues that provide excellent background in order to understand the evolution of the current freeze to seize conversation that has been unfolding in the EU, but also more broadly internationally. So let me share my slides and take you through the current shape of those conversations. And what I'm hoping to achieve today is to give a sense to those of you who don't live and breathe the freeze to seize discussion of where that debate is currently at, but also provide my estimation of some of the key legal issues that are involved in that discussion. And of course, at the highest level of generality, all of us know that with Russia's full-scale invasion of Ukraine, a significant amount of Russian property, both oligarch wealth, but also central bank foreign currency reserves, have been frozen across European and other quote-unquote Western jurisdictions. So in that sense, the starting position is similar to what we saw with misappropriation sanctions. But there's a key distinction. In misappropriation sanctions, as Celia made clear, the expectation was that the countries concerned, Egypt, Tunisia, and Ukraine, would investigate, and then confiscation orders would be issued based on which the property could in the end be lawfully confiscated. Here there's no expectation that Russia would carry out any investigation, or indeed no particular expectation that Ukraine would have the jurisdiction to issue confiscation orders that would enable the ultimate seizure of frozen property. But there is a political imperative to try and explore various options for seizing that property in light of the damage that is being caused to Ukraine. So that's one major chunk of issues I'm going to be addressing. And then I'm also going to say something about the other outer edge of current EU sanctions policy, which is the potential extension of Magnitsky sanctions to corruption-related designations. So my interest in this topic actually stems from the latter subject, that's to say Magnitsky sanctions, which was the topic of my PhD that was later published. So you see on your screen the topic of that, corruption and targeted sanctions, and that was really my entree to the broader conversation around sanctions. And over the past year and a half, I've been involved in several projects that looked at issues related to freeze to seize, and what you see on the right-hand side is one of the publications that sort of started off my interest in that. So where are we currently in the freeze to seize discussion? Well, there are three main topics that I want to address in that context. First, what do we know about the frozen Russian assets, to situate the discussion for those of you who, once again, haven't been following all the nitty-gritty. Then what has been happening in relation to private wealth, so that's the mansions and yachts that belong to oligarchs. And then finally, what is the current state of the discussion concerning sovereign wealth? How do we go about central bank foreign currency reserves? In order to provide some very brief general context and set the scene for more detailed discussion, I think it's worth mentioning that there are, as you know, many different types of sanctions, and all of the sanctions that we have seen under the sun have been applied in relation to Russia, perhaps with the exception of no-fly lists, which is a sort of sui generis category of sanctions typically applied against suspected terrorists by some states. But beyond that, we've seen the whole spectrum, from individual through to sectoral, and then all the way to state-on-state comprehensive sanctions. All of that has been utilized in response to Russia's actions both before and after the full-scale invasion of Ukraine. But in the context of the freeze to seize conversation, self-evidently, we're only talking about asset freezes, and we're talking about them, as I mentioned, in two different dimensions. the property that belongs to individuals or private companies, and the property that is directly owned by the Russian state. It's important also to mention that the current freeze to seize conversation is, in a sense, the culmination of this constant ratcheting up of sanctions that have been put in place in relation to Russia. Those sanctions didn't begin with the full-scale war in Ukraine, but really, I think, started in earnest with 2014 and the annexation of Crimea. What you have on your screens at the moment is a pretty simplified account of the incremental ramping up of the sanctions against Russia. You see the expansion both in terms of the types of sanctions that have been put in place, but also in terms of the countries that have joined the group and have supported the measures that were originally put in place by the EU and the US. So what we are seeing now is, I think, the pointy end of an ever-expanding, I'm going to mix my metaphors mercilessly, but ever-expanding array of sanctions that really generates a political will to go even further, and I think to push the boundaries of what is possible. And this is very much part and parcel of the context within which the current discussions are unfolding. So we've done everything that we could, sanctions-wise, in relation to Russia. Can we go beyond that? Well, one area where we can arguably go beyond is transitioning from the temporary freezing of assets to permanent confiscation. So it's, I think, one of those attempts to expand further the range of what is possible. When we talk about the public and private assets that have been frozen, those categories are not equivalent. And as most of you will be aware, the public assets, specifically the property that belongs to the Russian central bank, dwarfs the amount of private property. The estimates are somewhat imprecise, but I think we can draw some comfort from the statements by the multilateral task force, the repo task force that was established by the EU, the US, and other like-minded countries that have indicated in various briefings that approximately $350 billion in public property has been frozen across G7 economies, and around 58 billion in private property as of around 4 months ago. But I think that's by and large the most reliable estimate that we have so far. So private property is substantial, but as I mentioned, pales into insignificance compared to the state-owned property. And the other figure that is unascertainable, but sort of looms large in the background, is the amount of damage that Ukraine has suffered, which of course is the raison d'etre for considering the options for confiscating Russia-related property. So where do we stand in relation to private wealth? By and large, there have been a couple of high-profile examples of very significant amounts of property being frozen. A couple of those instances relate specifically to the Russian politician and businessman Roman Abramovich, and here you see a couple of press clippings, and there have been a couple of other people as well. But I think it's also fair to say that from what we know, this property tends to be distributed across a range of countries, and we can't really say that there are particular countries with significant concentration. There might well be countries with significant concentrations of those assets, but we simply don't know. We can't say that out of the 58 billion that have been frozen, 20 or 30 billion is concentrated in country X. That is in contrast to the publicly available information in relation to state-owned property, where we know that the bulk of it is located in Belgium and has currently been immobilized in the accounts maintained by Euroclear, one of Europe's two main securities clearinghouses. So Belgium has catapulted into perhaps the unlikely or unexpected position of a country that holds the bulk of Russian state-owned property. And there are a couple of other states like France, Germany, and the UK that have substantial holdings, and that is somewhat in contrast with the private wealth that might as well be scattered in a more, in a more thin way across a range of countries. But there are limits as to what we know. So what is the current legal state of play? For some time, I think approximately for a year after the full-scale invasion of Ukraine, most of the policy proposals that were floating around were focused on private wealth, even though, as I mentioned, it actually accounts for the lesser bucket of available assets. But to set the scene for that, it's important to mention that very shortly after the full-scale invasion, a bunch of task forces were set up internationally and domestically. The key task force that coordinates international activities in relation to the enforcement of Russia-related sanctions, but also managing the freeze to seize discussion, has been the REPO task force, REPO meaning Russian elites, proxies, and oligarchs. Some of the key domestic, or in the case of the EU level organizations, are the Freeze and Seize Task Force in the EU, which some of the people in the audience here today will be intimately familiar with, and the KLEPTOTRACE Task Force in the US. What is noteworthy about the mandate of these task forces is that they explicitly refer those mandates to the freeze to seize discussion. So they're directed to consider the possibility of going for permanent confiscation, but it's also pretty clear that that confiscation is contemplated in the context of existing proceeds of crime authorities. For example, in one of his public statements, Didier Reynders, the chairman of the EU's Freeze and Seize Task Force, has stated that to confiscate, one must establish a link between assets and criminal activities. And a similar statement is to be found in the official mandate of the KLEPTOTRACE Task Force in the in the US. Of course, these statements are perfectly sensible, but they also highlight the key challenge that the EU and the US and like-minded states are facing in it potentially being difficult to establish a link between property and any criminal activities. And then that raises the billion-dollar question of, well, then, do you at some point reinstate the frozen assets to their owner? And what would the legal and policy and moral ramifications of that look like in light of that dire need to provide some measure of accountability and assistance to Ukraine, arguably using those frozen assets? So in the US, some of the discussion immediately turned to tweaking the existing of proceeds of crime regime, but also using pretty vigorously the existing authorities for the confiscation of property connected to criminal activity. Now, one of those options that was used particularly energetically so far is confiscating the quote-unquote proceeds of sanctions evasion. And the legal theory there is entirely straightforward, similar to the discussions that one might have about the confiscation of the proceeds of tax evasion. Even though tax evasion or sanctions evasion don't actually generate property for the person who's involved in those activities, effectively, they're more accurately described as hiding the property from the government. Nonetheless, the proceeds of those activities are liable to confiscation in a number of jurisdictions. The US is one of those jurisdictions. And what you see on the right-hand side here on your screens is a Medea. A Medea is a yacht owned by a Russian businessman who was designated by the United States and attempted, at first successfully, to remove the yacht from the jurisdiction. Well, yacht conveniently can sail, and he thought, well, why don't I sail away from American shores and in that way remove the yacht from the US jurisdiction? The problem was that in that way, according to the US government, he became engaged in an attempt to evade US sanctions. So a mutual legal assistance request was filed with the authorities of Fiji, the country where the yacht at the time was anchored, and then the yacht was duly seized and returned to the US. Now, that is one spectacular example of the use of those authorities that are granted by laws that enable the government to seek confiscation or forfeiture of the proceeds of sanctions evasion. Legislation was also adopted in the US throughout the first year following the full-scale invasion of Ukraine that enables the government to transfer confiscated funds that stem from sanctioned oligarchs to Ukraine. There were also a couple of further reforms that were proposed in April 2022, but have not been adopted. One of those reforms would allow for the confiscation of property that merely has a connection to specified unlawful activity, as opposed to constituting the proceeds or being an instrument of such unlawful activity. But once again, I would describe that as tinkering around the edges of existing proceeds of crime laws, and fundamentally none of that alters the basic premise, which is that property is liable to confiscation if it is involved in, or rather if it stems, or if it is involved in criminal activity. What about the EU? Well, I think that the example of the US has not gone unnoticed, and the European Commission proposed a directive last year in May that contained a number of reforms, including requiring EU member states to enable the confiscation of the proceeds of sanctions evasion, effectively in line with what we saw in the US. And there were also a couple of other reforms that pertain more broadly to the operation of the proceeds of crime and asset recovery framework in the EU, such as new freezing powers for asset recovery officers in member states and new rules on the management of frozen assets. The way that I would describe those reforms, which I do not believe have been agreed or have not passed yet, is that once again, they are perfectly sensible in their own right, and they make a lot of sense if one goes back to the drawing board and thinks, how can we improve the EU's proceeds of crime regime? In the context of the specific issue of freeze to seize, I don't think that those would be a game changer, because they don't alter that fundamental premise that one has to have proceeds of crime in order for property to be confiscatable. And with most of the private property that has been frozen under Russia-related sanctions, the ability to prove connection with any criminal activity that might have happened 10 or 20 or 30 years ago in Russia is, I think, illusory. Of course, there's the fallback option of confiscating the proceeds of sanctions evasion, but that works against people who are impatient, people who prefer to sneakily remove their yacht from its port in the Mediterranean, as opposed to challenge sanctions in the Court of Justice of the European Union. And that's not me trying to be cynical, but I think it's probably a fair assessment of the impact that those reforms would have on the specific freeze-to-seize problem that has arisen in the context of Russia-Ukraine, as opposed to the broader question of whether those are sensible reforms, which I think clearly they are. Now, Canada has been the front-runner, perhaps the unlikely front-runner, given that we don't know that Canada has all that much Russian property frozen there, but has been the trailblazer in going after frozen property in a really aggressive fashion. And in the year after the invasion of Ukraine, Canada adopted amendments to its two main sanctions laws, the Special Economic Measures Act 1992 and the Sergei Magnitsky Law 2017, to enable the forfeiture of property belonging to a sanctioned person. The legislation is pretty draconian in that there don't really seem to be any serious preconditions to the forfeiture of property beyond it simply belonging to a sanctioned person. There are a range of requirements that need to be satisfied in order for the property to be frozen in the first place, but once it's frozen and once it's established that it belongs to a sanctioned person, the property is liable to confiscation. So far, it seems that one case has been brought under those new amended laws. It concerns the person I already mentioned, Roman Abramovich, and I think around 27 million Canadian dollars. So we'll see how that plays out in court. But importantly, the Canadian legislation does not currently enable the confiscation of state-owned property. So the Canadian Sovereign Immunities Act continues to operate and is not in any way abridged by the adoption of this new legislation, which therefore only affects the position of private property. And I think that the Canadian approach is really interesting in that it does throw up a genuine rule of law dilemma. I think that if governments are tempted by that aggressive Canadian approach, then they need to answer one fundamental question. And that question is what you see on your slides. Can one confiscate property that is not proceeds of crime? The Canadian answer to that is yes. The EU and American answer so far has been, well, actually, no. We can tweak the definitions. We can maybe try to confiscate something that has a connection to a crime rather than being the proceeds. Maybe we can confiscate the proceeds of sanctions evasion, but fundamentally we still need to have that nexus to a crime. The Canadian approach dispenses with that nexus, and this is what I think makes it so radical and potentially appealing, but also I think it's evident for all of us that there's a genuine rule of law dilemma that is involved there. Interestingly though, once you froze the assets, I don't think there are any risk-free options for governments, because in the current political climate, and given all the factors that I mentioned related to the ongoing destruction in Ukraine and Russia's unwillingness to comply with its international law obligations to make full reparations, it's difficult to imagine a situation where much of the frozen property would be restored to the owners. Well, what happens if you keep the assets frozen indefinitely? Surely at some point that in itself is a significant interference with the right to property that potentially amounts to something that one might describe colloquially as expropriation of property. Now, that is an argument that has been floated every once in a while in terrorist sanctions cases, most notably in one of the installments of the Cardi saga. And so far, the CJEU has been reluctant to accept that freezing the assets indefinitely is in fact a violation of the right to property. But in Cardi, in the paragraph that you see cited on your screens, the General Court seemed to be open to that possibility and said, well, look, if assets are frozen for a very long time, then potentially we might have to reconsider the notion that sanctions are a temporary and preventative measure. At some point, it's possible for them to feel more like a permanent and punitive measure instead. So it's very much a nascent risk, a risk out there on the horizon. I think that at some point it is a risk that might have to be confronted if there's no other resolution that is found to the issue of what one does with the private property that has been frozen. So a really difficult rule of law dilemma there, compounded by the fact that the end game is unclear, and if the assets are simply frozen indefinitely, that has its own risks. So what about sovereign property? What about the real big ticket item, the 350 billion? As you can imagine, there's a whole can of worms that is opened once one starts talking about the potential for seizing sovereign wealth. And I think that a convenient way to think about those different issues is to separate them into two buckets. So forget for a moment what you see on the screen, but the first bucket would be domestic law issues, and the second bucket would be international law issues. Domestic laws generally can be amended by parliaments, There might be constitutional issues related to the right to property or human rights issues connected with that, but they seem to be, generally speaking, attenuated, because here we're not talking about private property, but rather the property that belongs to another state. And so there's a serious argument to be made that under both international human rights law, but also potentially domestic legal frameworks in a number of jurisdictions, state-owned property doesn't actually benefit from constitutional or human rights protections that would be accorded to private wealth. So generally speaking, even though there tends to be no domestic basis for the confiscation of another state's central bank property so far, that can be amended. So the real issue is that second bucket, international law, something that states cannot amend unilaterally, and something that they ought to observe as they contemplate the potential move from freeze to seize. So if we focus on that second bucket, international law, I think there are two main categories of questions that arise there. And you see those on the slide here: sovereign immunities and investment treaties. And these are the issues I'm going to take you through in just a moment. But before I do so, I think it might be helpful to give you once again a quick sense of, or a quick overview of the legislative initiatives that have been unfolding so far. So over the next couple of slides, you're going to see a gallery of photos of happy people who are happy because they want to confiscate Russian state-owned property and hand it over to Ukraine. Now, I'm being a bit facetious, but the US bill that was tabled a couple of months ago was proposed by a bipartisan group of legislators, both from the House of Representatives and Congress. And here you see Senator Jim Risch, the ranking member of the Foreign Affairs Committee in the US, so the most senior Republican on that committee, who tabled the bill with the support, as I mentioned, of a bunch of his colleagues. The bill is called the Repo for Ukrainians Act, which stands for Rebuilding Economic Prosperity and Opportunity for Ukrainians Act, introduced in July 2023, and it is pretty far-reaching in terms of what it envisages. It provides for the outright confiscation of Russian sovereign property within the jurisdiction of the United States, the use of that property for compensating and supporting Ukraine through the creation of a dedicated account that will be administered by USAID and the Treasury, but also it authorizes the United States government to seek the establishment of an international mechanism for the disbursement of confiscated Russian property for the benefit of Ukraine. Interestingly, the Repo Act in its current form excludes judicial review as long as Russian state-owned property is concerned. So it doesn't preclude any due process claims being brought by private individuals or companies if they are affected by the confiscation. If, for example, it turns out to be the property of a private Russian company rather than the Russian state. But if the property belongs to the Russian state directly, there's not going to be any judicial review if this bill is adopted in its current form. So this is a pretty ambitious legislative proposal. As you can see, given that it's only been introduced a couple of months ago, not an awful lot of time has passed. So we'll see what awaits that bill in the future, but it will be definitely an interesting one to watch for. Now, in the EU, as many of you will know, there's a bit less certainty in terms of the proposals that have been put forward. There have been indications in the press that the European Commission is proposing to create a new structure to manage frozen and immobilized public Russian assets, invest them, and use the proceeds for Ukraine's benefit. I think it's pretty clear that that is the current shape of the Commission proposal. We don't quite know to what extent member states are on board with that idea. And we also know that the European Commission had commissioned a study on the legal aspects of the freeze to seize conundrum around November 2022. We're not quite clear, I think, based on publicly available information, how exactly the legal assessment played out. And in particular, I think the key question is this. The current proposal by the Commission is to, in a sense, hand over to Ukraine the interest that is being generated on frozen Russian assets, such as cash and securities that are being held in Euroclear. But from the standpoint of sovereign immunities, presumably that's not dramatically different, if at all, from confiscating the principal. What's the difference in legal terms or in sovereign immunity terms between taking the principal and taking the interest? Those would seem to be equivalent propositions. So I think it's fair to say that we haven't seen a public articulation of the precise legal reasoning that has led the Commission to go down that road, but maybe we'll see that with time. So really interesting question there. But this is the current halfway house that the European Commission is proposing to set out. Let's not touch the bulk of the frozen property, but let's invest it and take the interest. And in the UK, around, what would that be, 7 months ago, on the first anniversary of the full-scale invasion of Ukraine, we saw a bill being put forward by Chris Bryant MP, a member of parliament for the opposition party, the Labour Party, that would oblige the Home or Foreign Secretary to lay before Parliament a bill for the seizure of Russian state assets for the purpose of offering support to Ukraine and Ukrainian people. So this bill would in effect direct the government to take more concrete action on freeze to seize, but didn't really engage with the granular detail of what that would look like. The government seems to have been opposed to that proposal because it blocked the second reading of the bill in late February this year. Now, when that happened, the government said, look, we don't actually oppose the bill in principle, but we are not happy with the speed with which it was proposed. It doesn't really fit with our priorities in terms of managing the parliamentary pipeline and so on. But the bill hasn't progressed since then, so it does appear as though the British government so far has been somewhat reluctant about that idea, and this is why the bill hasn't made much headway. So what I think we have as a bottom line is the US proposal that's currently doing the rounds around Congress, is being discussed in the media as the most ambitious freeze to seize proposal as relates to state-owned property. So that brings me to the actual legal issues that arise. And I think those legal issues are pretty intuitive. They relate to, first, sovereign immunities, and second, the investment treaties that a bunch of countries have in place with Russia, including most European countries that have frozen Russian assets. Interestingly, the US has a treaty in place with Russia that has been signed but not ratified, therefore not in force, but the position is different for pretty much all other European countries that are relevant, or all European countries that are relevant in this context. So this is where we, as it were, approach the boundaries of the known legal landscape. And it's really interesting because in broad brush terms, the issues are quite clear. First of all, would the confiscation of Russian state property engage sovereign immunities? And secondly, would it constitute an expropriation without compensation? But then there's another question, a broad question that overlays those other two issues, and that's the applicability of the law of countermeasures under public international law. And as many of you will be aware, under the law of state responsibility, it is possible to temporarily deviate from one's obligations vis-à-vis another state in response to that state's own prior breach of international law. There are a bunch of requirements that have to be satisfied importantly, countermeasures can't be punitive and they have to be proportionate. But beyond that, countermeasures offer a way for a state to say, okay, we're not going to comply with our international obligations because of your own prior breaches of international law. And that adds this extra layer of complexity, because not only do we have to consider sovereign immunities and investment treaties, but we also need to bear in mind the potential interplay between those areas of law and the law of countermeasures. And when we talk about sovereign immunities and countermeasures in particular, then we're engaged in interpretation of customary international law that is not codified, even though there are authoritative sources of what that law generally says in broad terms. It's not fully codified, and there can be uncertainties around the edges. So what are the key issues that people have been discussing in connection with each of those big questions? Well, first of all, when it comes to sovereign immunities, it's uncontroversial that the law of sovereign immunities protects state property from being seized in the enforcement of a court judgment by the court of another state. The fact that most domestic legislation around the world, relevant international treaties like the UN Convention on State Immunity, which hasn't entered into force but is nonetheless considered authoritative, and the documents published by the International Law Commission all speak of immunity from measures ordered by the courts, raises the question of what happens if confiscatory measures are ordered by the executive. What if the courts are not involved? Well, what about a law that directly confiscates certain property through legislative action? It would seem bizarre to suggest that that would not trigger the application of the law of sovereign immunities. But interestingly, if one looks at the current sources of the law of sovereign immunity, it might arguably be a plausible argument. But this is one of those areas of great uncertainty. How does one interpret the scope of protection that sovereign immunities confer on state-owned property? I think there's a finely balanced argument of great complexity to be made there, and some people are debating that point vigorously. And that, I think, is the key question there in relation to sovereign immunities before one considers countermeasures. As relates to investment treaties, virtually all, I think all investment treaties protect private property from expropriation without compensation. The question is, does that apply to the property that is owned by a state directly? Well, what about the central bank of a state? There is some case law by international arbitral tribunals to the effect that states and state-owned enterprises that don't fulfill commercial functions but are an extension of the state don't benefit from those protections. But I think that is a point where we don't have complete certainty. Another issue that arises there is that not all takings rise to the level of expropriation without compensation. For example, it's generally accepted that forfeiture or confiscation of the proceeds of crime would not constitute expropriation without compensation. It's still a taking of property, but it's not expropriation. Well, what about the taking of a property that is aimed at compensating the victim of a war of aggression? Is that something that is sufficiently proximate to the forfeiture of proceeds of crime? Is that something that fulfills a pressing public interest in a similar fashion? Is that something that simply doesn't fall within the ambit of that broad prohibition of expropriation without compensation? Another difficult issue to which we currently have no fully convincing or settled answer. So we have those pockets of uncertainty around both sovereign immunities and investment treaties. And then we have the overarching question of countermeasures. Well, even if otherwise confiscatory measures would be incompatible with international law, what about countermeasures? Do they salvage the situation? This is where I think most of the current international law conversation is focused. I think this is arguably the most plausible path to the potential confiscation of frozen property in these particular circumstances, but there are challenges there as well. It's uncontroversial that countermeasures can be taken in response to a breach of international law by another state. There is some uncertainty around what is known as third-party or collective countermeasures. So if you are not the directly injured state, if you yourself are not a victim of the war of aggression, can you nonetheless take countermeasures in response to the violation that occurred? One school of thought would say that the answer is yes, because some obligations are owed to the international community writ large, erga omnes obligations. The other school of thought would be much more circumspect about those third-party countermeasures, because they would think that that is a shortcut to abuse and manipulation of international law by powerful states. But I think, if I may express a personal view, it seems to me that the current weight of authority is inclined to accept the lawfulness of third-party or collective countermeasures. The perhaps bigger challenge there is that while everyone agrees that countermeasures must be proportionate and cannot be punitive, there is some disagreement as to the requirements of temporariness and reversibility. Countermeasures should in general be temporary and reversible. Does that mean that confiscation is by its nature incompatible with lawful countermeasures? Because confiscation is not temporary and it's not reversible. There are different views on that topic, and I think that would probably be going too much into the weeds, but there is a respectable argument that would say, look, the real principle at stake here is that countermeasures need to restore the state of lawfulness as between the two parties. They're meant to restore the proper state of compliance with international law, and they must not be punitive and they must be proportionate. So if we have a state that owes the obligation to pay reparations, on that view, it would be permissible for countermeasures to be used in order to take frozen property of that state and use it to pay the reparations, but not go beyond that. As long as the use of frozen property remains within the bounds of payment of reparations, on that view, countermeasures are lawful. But there's, as I said, quite a lot of uncertainty and debate currently around the proper interpretation of those requirements that exist under international law as relates to countermeasures. So how would I then summarize, with all of that abundance of information, the current state of play on the freeze to seize debate in the EU, but also internationally? So in relation to private property, we're seeing a true rule of law dilemma. If you want to move from freeze to seize, presumably you have to compromise on the protection of private property. And some countries are willing to experiment, for example, Canada. And if you're not willing to compromise, then you still need to think of an end game. What is going to happen with those assets down the road? Are they going to be reinstated to their owners? When? Under what conditions? Or if they are simply going to remain frozen for the foreseeable future, what are the risks related to that? Now, in relation to state assets, I think politically and economically, it's a much more challenging proposition, because we're talking about $350 billion worth of property, frozen in a coordinated fashion, potentially in the future confiscated in a coordinated fashion. So it's only proper that there's great caution there. But if we look at the legal complexities and peel them away layer by layer, then I think, at least my conclusion is that there is a perfectly plausible path for confiscation under international law. And so ultimately what governs the issue is policy and politics, not the legal challenges under international law. The real question there is it a good idea, politically and economically speaking, not whether it's legally possible? That would be my view. You might disagree with that assessment, but I hope at least I have provided a generally decent overview of the issues that are involved. Now, unless Giovanni steps in to tells me that I'm wrong, I think I still have approximately 10 minutes for a brief discussion of the Magnitsky sanctions, which is a wholly separate matter. So, it's a bit artificial to, as it were, stitch them together in this presentation, except that it's also an interesting and important topic that, as I said, is somewhere on the outer edge of current sanctions developments in the EU. As many of you will know, the EU has had for some time now the global human rights sanctions regime for human rights abuse. And last year, Ursula von der Leyen committed to the introduction of a corruption-related sanctions regime. And then with time, that proposal has been progressing. And I think we've seen another indication by the European Commission of its endorsement of that idea. And that really raises some interesting questions about the purpose and effect of so-called Magnitsky sanctions. So first of all, what are they? Well, Magnitsky sanctions are, as many of you will know, so I hope you will forgive me for repeating that very briefly, asset freezes and travel bans that are imposed by reference to corruption and human rights abuse. It's as simple as that. Now, the reason why we call them Magnitsky sanctions is in homage to the original Magnitsky law that was adopted by the US in 2012 in response to the killing of tax accountant Sergei Magnitsky in a Moscow jail in 2009. Now, at the time, his employer, Bill Browder, launched an energetic campaign to achieve some measure of accountability for the death of Sergei Magnitsky. And one of his ideas in doing so was to say, well, look, people who were involved in that crime like to travel abroad, they like to invest abroad, so why don't we try to deny them that ability? Why don't we try to get other countries to impose asset freezes and travel bans? Now, at the time, the United States government had some existing legal authorities for the imposition of travel bans, but not asset freezes. And so as those discussions progressed, it became apparent that a new law is necessary. And that law was adopted in 2012, and it bears the name of Sergei Magnitsky. And in one of the eloquent statements that were uttered when the act was adopted, one of the co-sponsors, Senator Ben Cardin, said that the act enabled the US government to see beyond the veil of sovereignty that kleptocrats often hide behind. The point being that there's no hope of any credible investigation in Russia, but there is a need for a credible international response. So this is where the notion of Magnitsky laws comes from. And since then, we've seen a proliferation of those laws around the world. So what you see here is my attempt to summarize the current Magnitsky legislation worldwide. And as you see here in the United States, in addition to the original Magnitsky law, which was limited to Russia, human rights abuse in Russia, we now have the global Magnitsky Act and the accompanying executive order that is applicable by reference to both human rights abuse and corruption. And we also have those earlier pre-existing travel ban related authorities that I mentioned. There's also a Sergei Magnitsky law in Canada that I already mentioned briefly today, which is very, very similar to the statute adopted in the US. There is the ability for the UK government to impose human rights related and corruption related sanctions under the 2018 Sanctions and Anti-Money Laundering Act. So even though the name Magnitsky is not used there, in essence, that's the same sort of approach that has been taken by the US and Canada. And in the EU, as of course we already discussed today, so far there's no self-standing corruption sanctions regime. There's a human rights sanctions regime, and there's the historical example of misappropriation sanctions that are kind of corruption related, but in this peculiar way that Celia has been discussing. So one of the questions that I think the extension of Magnitsky sanctions in the EU would raise is, what's the point? What's the kind of impact that those sanctions generate? Are they really effective? And this is a fraught question, and I just wanted to draw your attention to a piece of work that I did very recently on that very issue, where together with an organization called the International Lawyers Project, we looked at the first 20 corruption-related designations in the United States that were imposed around 5 years ago when the Global Magnitsky Act came into being. And we asked the simple question of, okay, during these 5 years, since those sanctions, what happened to the people involved? What is the impact that they have suffered? And I would just direct you, if I may, to this report if you'd like to get further information on the kinds of impact that we saw and the prevalence of it and the way that they correlate with different personal characteristics of the person targeted. But in the time that I have remaining, the headline message that I would give is that I think it's really important to note that the impact of sanctions is not limited to what we call the direct impact. So yes, asset freezes and travel bans are important. They are the immediate consequence of Magnitsky sanctions, but there's this whole slew of other second-order categories of impact that we separated across 3 categories: private sector action, home developments, and behavior change. Because private sector actors react to sanctions designations, even if they don't necessarily need to do so in terms of legal compliance. There are still reputational pressures that they bear, and so we see non-US banks ceasing to do business with people who are targeted because of US sanctions. We see other companies doing the same, not only banks. We see media scrutiny. There are potential developments back in the home country, and of course the holy grail, many people would say, of sanctions is achieving behavior change by the target or by the broader regime or network. So I think I don't want to overstate the point, and there were 1/3 of cases in our sample where we didn't see any impact of sanctions at all, but in 2/3 of our cases we did observe some form of impact. So sanctions are obviously by no means a silver bullet, nothing is, but nonetheless there is some interesting evidence of corruption-related designations having some impact on the people who are being targeted. And I think this is something that is worth bearing in mind as the EU contemplates setting up its own corruption sanctions regime. So I think I will stop here, and hope I didn't go over time by too much. So thank you for your patience.
Many thanks, Anton, for your presentation. That was very interesting. I say that now we can open the floor for a QA session. So if there is anybody who wants to raise the hands, write into the chat and ask the question, we'll give you a few seconds. Otherwise, I may say that we thanks very much all the relators, Matthew, Francesca, Celia, Anton, for the knowledge that they have shared with us today. So we have approached the conclusion on our first KLEPTOTRACE training. Our relators have helped us having a better understanding on the legal basis related to restrictive measure and asset freezing. That was the very key objective of this first training of the KLEPTOTRACE project. And of course, we thank all the attendees for their interest in the subject. I hope you found it interesting and useful for your purposes. So to conclude, I'd let you know that the materials from today's training will be delivered to you in the coming days. You can check your inbox in the coming days. And so just to say that during the next month, during the next year, for 2024, there will be several other trainings that will deal on the topic on how to identify, for instance, the risk of concealing proceeds of high-level corruption or sanction circumvention activities from the analysis of the features of company and ownership structure, and also how to use data-driven approach to increase the effectiveness of asset recovery initiatives. But apart from trainings during these 2 years of KLEPTOTRACE project, there will be several reports that will be out. For instance, legal and policy assessment and recommendation on the EU and national sanction frameworks, and also reports that describe the latest trend that are observed in the high-level corruption and sanction circumvention scheme. So we invite you to continue to stay informed with the KLEPTOTRACE activities, and I genuinely hope that our path will cross again in the near future. So thanks again for being with us today, and I wish you everyone a good day. So many thanks.